Adjournment request, if any, from item number 1 to 4. From item number 5 to 13.
Lordship, with regard to item number 13 and 14, Your Lordship, I am the appellant for item number 13. Lordship, we pass over the matter for today, Your Lordship. That will be concern has been adjourned. Lordship, and there is an interim order. Let us slip or not? Lordship, yesterday an adjournment slip was circulated via email at 6:30, Your Lordship, actually.
Fine. In item number 13, I am for the appellant, my lord. Item number 14, my lord.
14, yes, sir. 14, okay, listen. Lordship, there is an interim order that will circulate action from the other side. Listen, Lordship, the interim order may be extended. Interim order, if any. Extended. Much obliged, Lordship.
May I please, Your Lordship, the concern of the other side, Lordship, I beg to mention item number 19, 20, and 21, Lordship. Lordship, I'm praying for adjournment, my lord. Another date may be fixed. Some instruction are required to be taken from the
From whom?
from the railway department, my lord.
What about the position of the work?
Lordship, on that point only instruction was required. My lord.
The request was made on behalf of the council for the appellant with no objection from the other side for adjournment. Adjourn.
Much obliged.
Yes.
May it please your lordship, with the consent of the other side, I beg to mention item number 11, your lordship. As the out of station council is not present here. In item number 11, and for the
Request is made. This month of August.
deeply obliged to you.
Yes, please, my lord. I'd like to mention item number 17, my lord. There's a slight difficulty today. The arguing council, my lord, may kindly fix the matter next week if my lord may.
The general slip is already
Circulated, my lord, with the consent of the
adjourned month of September.
obliged, my lord.
Any other request?
Lordship, may please your lordship, lordship with regard to item number 24, it was listed day before yesterday, your lordship. I'd like to withdraw this matter, lordship. I am for the appellant here, lordship.
Well, there is a small prayer, my lord. The matter pertains to my lord, supply of medical oxygen, my lord. Only thing, my lord, because the
Tenders have already been
yes,
floated.
my lord, till that time the interim arrangement, my lord, that may continue, my lord. That liberty may be granted to us.
Lordship, I will not like to peruse the matter because lordship, I will participate in the upcoming tenders. Continue the pursue the matter. Concept of the appellant has submitted that in view of the subsequent development. I have instructions, your lordship. In view of the on instructions has submitted that on view of the subsequent development, the appellant is not pursuing this writ appeal. And the writ appeal is over till the finalization of the new tenders, the interim arrangement.
My lord, dated 29/8/24.
As ordered by this court or
29/8/24.
29/8/2024 shall remain in current.
Only thing, lordship may use the word liberty, my lord. Liberty will be given to the government to continue with that particular interim arrangement, if they want, my lord.
In that case, lordship, I will also participate, lordship.
Of course, he will participate in the fresh
There is
tender.
no bar. The concept of the tenant on instruction that since new tenders have been floated for the purpose of obtaining liquid, which gas is this?
Liquid medical oxygen.
Liquid medical oxygen. The appellant does not want to press this writ appeal. And this writ appeal is dismissed. With liberty with the state government to continue with the arrangement,
Yes.
interim arrangement and ordered by this court on
29/8/24.
29/8/2024. Till finalization of the new tenders.
Highly obliged.
Much obliged. Yes,
Daily list for orders, item 1.
The instructions which I had received, all the three have also been allowed to join in the different schools, my lord.
in the other schools.
My lord, yes. Two of them against new existing vacancy and one in the original school itself. The
Well,
first
so
phase
one
itself.
part of the order is complied so far the appointment is concerned. There is also another part of your lordship's order in regard to the salary that they have not paid.
They'll do that.
Your lordship will, your
If
lordship,
they are appointed, then what remains?
no, the area salary they have not paid. Your lordship will kindly keep note of one thing. Your lordship has passed the order in 2018.
Yeah.
We filed the contempt petition within 1 year from 2018. Now we are in 25. It is not because of our fault that we have not been appointed. And we were appointed in 2001. And my lord, salaries has been paid from 2005 to 2010. From 2001 to 2005 till 2025, in spite of a specific direction from this honorable court in 2018, they have not paid the salary and the consequence.
There no specific direction of the court is there.
Your lordship will kindly observe.
Yes, read.
Yes, sir. Page 27.
Yes, read.
We accordingly set aside the termination order dated 2/11/2022 issued by the Director of Elementary Assam, as well as the judgment and order under appeal dated 7/8/2014, passed in WBC number 6071 of 2010. Save and accept the order directing for payment of salaries to the appellants for the period they work. So that they have not yet paid. Your lordship has not even interfered in the learned single judge order directing us to pay the salaries, my lord.
Okay.
So if your lordship wants to close the matter,
Yes.
then your lordship will kindly direct them to pay the salary within a time frame. Otherwise, this-
This record is assurance.
yes, madam.
Pursuant to the order passed by this court on 8/5/2025. Learned counsel, Mr. R. Majumdar, learned counsel appearing for the contemnants has submitted that all the three persons whose names were referred in the order dated 8/5/2025 have been provided posting in the other schools on vacant posts. Full stop. Taking into consideration the above facts and circumstances of the case, we are of the view that the order passed by this court has substantially been complied with. Hence, no further order is required to be passed in this petition. However, so far as regarding salary part is concerned, Mr. Majumdar has assured this court that if any payment is due against the salaries of the petitioners, the same shall be paid. The same shall be determined and paid within a period of
3 months, my lord.
6 weeks.
You are obliged, sir.
Supplementary list for admission, item 26.
Please, your lordship. Here we have challenged the, my lord, impugn notice of auction, my lord, of tea garden assets, my lord, immovable and immovable property by the respondent bank, my lord. And the petitioners, they are representing the workers of the tea garden, my lord. And the workers did not receive their wages since March 2024. Only later on, they came to know that the owner of the, my lord, tea garden has taken a huge amount of loan from the bank, and because of being unable to repay the loan, my lord, the tea garden has been taken over by the bank, and now they are having the interim notice to for auction of the property, my lord. The grievance of the petitioners are that their wages must be cleared first, my lord. My lord, since the bank has taken over, my lord, as per rule, my lord,
Without auctioning the property.
my
of the
lord,
bank,
earlier,
clear the wages.
that is there, my lord, but earlier, my lord, my lord, another writ petition was filed by kindly say annexure B at page 17. It was filed by the Assam Tea Employees Provident Fund Organization at page 16, 17, and 18, my lord. There was an interim protection here, my lord. Taking into consideration, it is submitted that as per the provision of Rule 9(7) of the rules of 2002, the purchaser first have to clear the encumbrance and then only sales certificate would be issued. Taking into consideration the above facts and circumstances of the case, we allow the respondent bank to issue a fresh sale notice of the property concerned. However, the amount received in the sale shall not be disbursed or adjusted
That is in
against a
relation to
particular.
the provision for-
Similar, my lord, similar,
That
my
is-
lord,
What
protection.
similar, what similar? Where is the determination of your wages?
My lord,
Who has determined your wages that this much? of
wages will
is-
be determined by the, my lord,
Where is the
respondent.
determination?
There, I have made
If you are
the,
agreed by the auction, go before the DRT.
they will go, my lord, but
Yes, go before the DRT.
at least till then, my lord,
No, not done, nothing. Simply because you have filed this petition, which is not at all maintainable. We are not supposed to pass any interim order. Approach the DRT.
the wages, my lord, wages I have given the, my lord,
Madam, who has
at
determined
page,
it is
my
your
lord, para
contention?
4, my lord,
It is your contention, but who has determined the due wages?
the wages will be given the garden authority,
Where
my
is
lord.
the determination, ma'am?
Yes,
You
determination
simply
must be
said
made,
that,
yes, my lord.
the wages have not been paid since March
Wages, since the
2024.
wages, my lord, that 238, my lord. Your lordship may kindly see page para 4. The petitioners beg to state as prescribed under the Minimum Wages Act, the daily wages of the each worker is 238, my lord.
Okay, ma'am.
daily.
Who has determined?
Determined,
since when
it will
is
be
due?
determined by, since March 2024.
Madam, where
It
the
will be determined by
determination?
the authority, my lord, under whom they were
Who the
working.
authorities, how
The
the
garden
bank is
authority,
supposed
my
to,
lord.
how the bank is supposed to determine that?
That is there.
Where is the determination? Where is the
Determination must be made.
encumbrance on that property regarding the wages? Where is that?
That should have been made by the authority of the garden, my lord.
So then how the bank is concerned with that?
But I have made the party, my lord, the bank manager of the, my lord, TSP.
How the bank is concerned with that?
My lord,
What
my
is the
lord,
role of the bank in determination of the due salaries?
but at least, but they cannot, my lord, sell the property without
They
clearing
are
the
not selling the
encumbrance.
property. The bank has took the possession, and bank, as per the Surface Act, they are auctioning the property.
Auctioning the property, my lord.
Yes, that is as per the securitization act. If you are agreeing, challenge it before the DRT.
Before the, yes, my lord.
Challenge it.
Yes, my lord.
So now you are withdrawing it.
Yes,
Then you concept of the petitioner. The matter for quite some time. On instructions, wants to withdraw this writ petition with liberty to the petitioners to approach the DRT against the auction notice issued by the bank if law permits to do so. This was with liberty as the way law.
Daily list for hearing, item 2 and 3.
My lord, item 2, my lord. I have been just engaged by my lord. Here the virus of the 2006 Act is put to challenge. Subsequently, my lord, in 2018, there is another act. It must be brought to your lordship on the court.
Once this act is already repealed and another act is there, challenge it.
No, my lord, that it has some bearing on the earlier challenge made. It is the present act is Assam non-government education
If the-
institution.
If the act is already, the act which is under challenge is no more.
It is there, my lord. We are challenging the virus of the 2006 Act.
Okay,
It is there. That challenge, subsequently, there is another act, I just came to know a lot. Assam Non-Government Education Institute Regulation of Fees Act. Act has bearing on the challenges made by us. Because the fees is a factor, my lord, that has to be, my lord, considered, my lord. My lord, some time will be given, we brought it this on record.
Then it concern for the petitioner place some time to
That will be after 4 weeks, my lord.
prepare the matter list in the month of October.
No, Lordship, I have some reservations because some of the schools have not registered under this act. So they are getting the benefit,
Is
which
there
they are,
Is there any?
yes, Lordship, that is the issue.
What is the interim order?
Interim order that there should not be any efforts on our part to
There
compel
should
them
not be
to,
No,
they should not be registered.
no, my lord.
They have given that liberty. That
No, but-
liberty is given.
They cannot enforce anybody to register, my lord, not to register. That is the.
In fact, about 80-90% schools have already registered. Few are still left.
Where is the interim order?
You know, the- Huh? 22, 2016, it was passed. 22 to 2016, I'm told. now.
In fact, this matter was heard at length twice. Then the honorable
True,
Chief
the,
Justice says they were
oh, yes,
eligible.
Senator, it was
This
High
is also one batch of cases.
Oh, it is only a status quo, status quo. No? Then thereafter, what was that? Date? Hmm? 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 Okay. Who is it? But it is made clear that the stage of
The order is dated
22.
So,
22 to 2016.
this order was passed on your insistence.
This is in WPC 1891.
We have already seen, sir, this order was passed on the insistence of the state. The earlier clarified, the status quo order is clarified.
Yeah.
And it is, upon due deliberation, we deem it appropriate to alter the status quo order with an order requiring the petitioners to furnish their details to facilitate the preparation of the data non-governmental by the authorities, but it is made clear that this is registration of the should not be insisted, department or authority, and that it is ordered accordingly. And this was the request of the department had submitted that there is a presumption of so and so. Court should allow the registration of the private institution since the relevant database of the necessary. Thus, the respondent prayed the clarification of the status order passed by this court on 15/10/2000 to facilitate collection of data from the private school without insisting on the registration at this stage. That is what the,
Then subsequently, upon such due deliberation,
yes,
we deem it
they-
appropriate to
they were obliged.
alter
to-
the status quo.
They were obliged to furnish their details for the purpose of preparation of database of non-governmental by the authorities, but it is made clear that registration shall not be insisted. This is what your request.
And then that has been imposed by the honorable court, Lord.
This is your request only, sir. In the second para,
Let it come after summer vacation, Lordship, instead of October, Lordship.
September.
My lord, I'm for item number 3, my lord.
Yes.
Actually, my lord, we want to file an IA, my lord. Can it be listed on next?
Who is preventing you from trying?
My lord, we have got some real prayer, my lord.
No, so where is the?
Because
need for prayer
there are
for-
some orders has come out.
Where is the need for our permission for that? You file the IA, it will come.
My lord. Next week, my lord. I'll file it then.
It will automatically come.
Most of it.
Deputy of the Lord.
Item 4 to 9.
In respect of item number 14, which is 2015,
Item number?
item number 4, my lord. It's a 2015 matter. Matlab, today morning I have filed my wakalatnama. Lordship, kindly give me accommodation.
What remains in this matter?
Firstly, I need to take some
Now,
instructions, my
The
lord.
Honorable Supreme Court has.
Yes,
already
yes, that
decided
issue has been decided, my
in
lord.
the year 2020 itself.
Yes, my lord.
And whatever your, the SLP before the Supreme Court in respect of an order passed by the, in the IA, that
Yes.
has also been dismissed.
This means that liberty has been granted to file an appropriate. Lordship, I'll take appropriate.
What?
The main petition is not maintainable, my lord.
Lordship,
What appropriate?
one day, my lord, for accommodation for one next Monday, my
No,
lord.
We have already, you should have moved an application in advance, sir. It's a hearing matter.
Lordship.
It's not like that.
Yes, but today morning I have filed my
Why
wakalat.
you, gone through all entire files? This can't be the way, sir. You move, when the facility of moving this is available, why you have not moved this?
But yesterday only, my lord, I have received the file and today morning I have filed the wakalatnama.
Sir, whatever it may be, your objection in the petition is regarding section 15.
Yes, that has been
notification there
decided, my
issue,
lord.
only on the ground that the cooperative bank doesn't come within the definition of
Yes.
banking institution. Now the Supreme Court has clearly held in 2020 itself. It very well comes within the definition of
Yes.
banking institution.
Yes,
What remains in the petition, sir?
but let me take the instructions for one day, my lord.
Take, no, sir. No,
Or
either
a-
you take this instruction now, otherwise we are
But
going to
for
pass
time
it
being, my lord.
for the time being. In all other petitions, what remains in all the other petitions, sir?
So far, 7 is, my lord, covered by Supreme Court judgment, my lord. And
Which matter?
only thing that, my lord, I would say,
Which matter?
item number 7, my lord.
Or what about this this 5, 6, 7,
I am not on that, my lord.
5, 6, 7, 8, and 9?
I am in nine.
Yes, what remains?
The point whether T is agricultural and all of that.
That's absolutely
My
nothing.
lord, the only-
That is the issue still.
Dismissal shall not be a bar to consider our ODS proposal, my lord.
Sir, how can it be? How can it be? You simply challenge it and then.
No, my lord, that I am not
Time being,
This
my lord.
item number 7?
7.
And what about this, your item number 8,
Nine, your lord.
9? Sir, the persons who are appearing for the petitioners here,
I am for petition.
item number 5. Yes, what remains? Take your instructions, we are taking it after some time. Today itself. Either you should have moved an application in advance, otherwise we are not going to. What about item number? Then it's a order of 2020 and this can't be excused. You are not aware of the order passed by the court. That is for us to consider. We are not going to consider.
Lordship for item number 8, Lordship.
Yes,
Lordship, same issue, Lordship, whether cooperative bank can invoke surface act or not.
that is covered.
Otherwise, yeah.
And what about item number 6? Item number 6, then I'll.
They have a remedy under 70. They want to take it.
This item number 5, 6, 7, 8, and 9. These are all covered by that judgment of the.
But I have
Both
instructions.
is also covered by that.
My lord, I have item number 4, I have instructions to withdraw with liberty to approach the DRT. my lord.
That's- लिखना item number 4 when it comes to the petitioner on instructions as submitted that the petitioner wants to withdraw this petition with liberty to approach the appropriate remedy to avail the appropriate remedy available under the appropriate remedy before the appropriate forum in accordance with law. Dismissed with liberty as prayed for. Yes, item number
Obliged.
5 covered by that. लिखिए देना जरा वो 2029 SCC 21 in these writ petitions, the petitioners have challenged the action of the state government of the action of the Assam Cooperative Apex Bank and the other financial institutions of initiating proceedings under the provisions of the Securitization Act उसका पूरा लिख देना है. So act on the grounds that a cooperative bank cannot be termed as a banking institution. For the purpose of taking action under the Securitization Act. Full stop. It is noticed that the Honorable Supreme Court in Pandurangi Ganpati Chowle versus Vishwanath Patil, Murgur Sehkari Bank Limited reported in 2029 SEC 215 has already held that a cooperative bank which is registered under the state legislation or otherwise comes within the definition of banking institution for the purpose of initiating proceedings under the Surface Act. Full stop. In view of the authoritative pronouncement of the Honorable Supreme Court, we don't find any merit in these writ petition challenging the action of the respondent bank/financial institution. Hence, these writ petitions are disposed of. All the pending applications are also disposed of. However, the petitioners will be at liberty to avail appropriate remedy before the appropriate forum in accordance with.
Yes, sir, may I point out
5 to 9.
one point, Your Lordship, may I? In the matter you before the Supreme Court, Your Lordship, the issue whether tea garden land is agricultural land, that point has not been decided.
You challenge that before the appropriate authority. Yes, appropriate forum. We have already granted you the liberty.
Item number 10.
My lords, that passed an order on the 11th of March, looking at the changed situation as far as the law is concerned, where some deviations have been now made, my lord, from Uma Devi. My lord, I had sought for instructions, but then the issue, my lord, for us is larger because like pan India, there are different casual workers working. So what my current instruction is that, my lord, we want to have a homogeneous stand everywhere. So I require further my lord, at least 4 weeks time, my lord. If we have to proceed on this direction.
But now the Supreme Court has said,
Definitely, definitely.
at present they are working,
Yes,
even though maybe in that, whatever your scheme of regularization, they were not fit
My lord.
into it. But now looking to this fact that after so many years, from last more than around
Definitely,
3 decades, if they are
Yes.
working, then they require some.
we are trying to resolve it, my lord. And because it's not the only case, there are other cases in other high courts, my lord. We are trying to homogenize the stand,
Take a policy decision.
my lord. That is what. Some part of time, my lord, they also have a urgency.
The only inconvenience the petitioners are having is that, my lord, they are approaching retirement age. Once the retire,
Whatever it may be, we can't pass a decision because there are so many things. If they, tomorrow, if we come into this consideration that whatever the evidence which you have produced is not taken into consideration by the tribunal, then we have to remand it. Again, it will take some time.
Lordship can also take a call, my lord, going by the
But
document.
sir, looking to the fact that only the photocopies are there, then we have to record the finding, and they are saying that this original record is not available.
Yes.
That is the difficulty. So if they frame upon this
But
for
the
that
fact-
purpose,
True, my lord, but the fact remains that till date for last 25 years, they are working. That also
that's why only
complements.
That I have also agreed.
this judgment, even though if you
Yes.
are entitled even in that earlier scheme,
Yes,
but now in view of this latest judgment of the Supreme Court,
yes,
your case is liable for consideration.
yes.
That's why we have done.
My understanding is that this continuation of 25 years, perhaps that complements to the fact, those documents which I produced to substantiate my claim, my lord. That is my understanding, my lord.
Here we have to see this whether, because it's a judicial review of a cat order.
Yes. Cat, my lord, did not go to, in fact, Cat recorded a finding that,
We have some difficulty in, suppose a writ petition here, then we can direct it, but in a matter where the order is under challenge, there is some difficulty in passing those orders while exercising powers under Article 220. Essentially, if the petition under 227.
only thing is that, my lord, if they take, since they are intending to take some decision with regard to the petitioners, if they expedite that, my lord, that will be helpful for these persons, my lord.
Take a 4 weeks time.
Okay. On 11/3/2025, this court, while taking into consideration the fact that the petitioners were engaged by the BSNL years before and till date they are continuing. Has observed that as per the latest decision of the Honorable Supreme Court rendered in Jagu versus Union of India and others, and Anita versus so and so and others, we take this from Jagu versus so and so, reported in so and so. The case of the petitioners for regularization is liable to be considered by the respondents as per the latest law declared by the Honorable Supreme Court. Which law? Mr. B. Pathak got some time to complete his instructions. Today, Mr. Pathak has submitted that since the similarly situated persons are engaged, since the persons similarly situated to the petitioners are engaged, pan India, a policy decision is required to be taken by the BSNL in view of the latest law declared by the Honorable Supreme Court, and therefore you need 4 weeks further time to complete his instructions. In view of the above submission made by the made on behalf of Mr. Partner. this repetition listed after 4 weeks. However, we expect that by the next date of hearing, the respondent BSNL shall come with a policy decision regarding the status of the appellants, of the petitioners, considering the latest law declared by the Honorable Supreme.
Much obliged. Highly obliged.
Item 12.
It pleases your lordship. Lordship, on the last occasion, issue was raised regarding discrepancies that has occurred in the certified judgment and the judgment reported in the journal, lordship. Today,
We have the copy of that report. We have the copy of that report.
lordship.
Okay. You want to argue or not?
Lordship, the matter, if it is clear, clarified, lordship, the matter will
It is clarified now, we'll consider the certified copy which you relied upon on the last occasion. That is the certified copy of the judge.
lordship.
That is the, sorry, certified, that is the copy available with the record of the writ court.
Lordship.
So we have to consider that, not the judgment which you have filed along with the petition. Because the original.
My lord, it contains, my lord, more paragraphs.
Yes, contain more
Yes.
paragraph, certain observations.
Certain. So under that circumstances, my lord, if I may pray for the gracious leave of this honorable court, my lord, to have the copy, my lord.
Which copy?
My lord,
That is already reported. That is the verbatim.
no, my lord, may I apply for a fresh certified copy, my lord?
Yes, you can very well apply for that.
My lord, I will apply for a fresh certified copy, my lord, which will contain, if lordship directs to that extent, my lord, which will contain the entire judgment, then I may file an additional affidavit, my lord, with additional grounds.
Okay.
Because, my lord, amending the entire writ appeal will be cumbersome.
2025. This court has taken note of a discrepancy in the certified copy of the impugned judgment annexed with this writ appeal in comparison to the original copy of the impugned judgment available in the record of available in the original file of writ petition in bracket criminal copy of 2017. This court has ordered initiation of an inquiry this court has ordered the Registrar Judicial to conduct an inquiry into the matter and place the report before this court within a period of 15 days. Pursuant to the same, an inquiry report is submitted by the Registrar Judicial with the following findings. This page number, if we are finding present, this finding. Only. Only pending. Original record. Minute का. Following findings. From the inquiry report, it is clear that the deed and private secretary have uploaded the judgment dated 28/3, impugned judgment dated 28/3/2019 passed in writ petition criminal number 3/2017 without verifying the same with the original signed statement available in the case report. And the copying section also has issued the certified copy of the impugned judgment on the basis of uploaded copy without verifying the same from the original record the original signed judgment available in the case record. Taking into consideration the above facts and circumstances of the case, we deem it appropriate to direct the registry to initiate disciplinary proceedings against Ms. Sumita Das, the then private secretary, and also direct the registry to verify the direct the registry that before issuing the certified copy of any judgment passed in any case, should be verified that the uploaded online copy of the judgment or order are the same as available in the case record as available in the case record. Full stop. Then it, once it appearing for the petitioner as requested, sorry, appellant has requested that the registry be directed to supply him certified copy of the judgment available in the case record of writ petition criminal number 3/2017, so that if it requires so, the writ appeal be amended suitable. Stop. Copy may be furnished to us also, members. I also don't have. The copy of the certified copy of the judgment, original signed judgment available in the case record, we also supply to the consent for the respondent. Stop. This Then petition after 4 weeks, and then again after 4 weeks. DPO obligement. And so obliged.
Item 15.
May I please your lordship? So,
Yes.
Lordship, I need some accommodation, Lordship. In this case, I am led by Advocate General, Lordship. He is in another court, long matter, Lordship, in court number 10, Lordship. Issue is, my lord, very simple. We worked for last 6 months. They did not pay us the salary. Their basic contention is that,
What happened, later on your services have been terminated?
yes, because when we worked, at the time, there was no inquiry. After, when the court directed for payment,
Termination on what ground?
my lord, because when we were appointed, they said that there was no advertisement.
Or something,
They want to say that it is irregular appointment because there was no advertisement.
that is the only reason.
Yes, ma'am.
Do you have the termination order?
Yes, it's, but he has requested for me. Yes.
Termination order.
No, it was Saturday. On the last date, I have placed the termination. Page 104 to 134 are the,
10.
but there will be some mistake because in the pagination of the copy that was served and my lord, the court copy may be different, but the termination orders. It's in the affidavit filed by Shri Prasanta Borkakoti. Your lordship will find it. Additional affidavit filed by the appellant to place on record the termination orders. The last one. Enquiry report is on. The petition order to complete. Without cause. Your lordship will kindly take note of the order of the termination date. It is 30th of July 2022. Whereas the date of judgment of this honorable court directing to pay a salary was 27th of June 2022. Prior to it,
Only
6/2022.
so only about 6 months salary.
Only 6 months salary. We can't be treated as slaves, my lord, because there was a direction from the order of this court that you
The
cannot come
question
in.
is when, if your appointment itself is treated as illegal, then
No, my lord, there
we challenge this order. of
this termination.
Termination
Yes.
pending.
Yes, in this case. Okay. Yes, pending. Before this honorable.
Separate
Yes.
proceedings.
Not everybody has challenged.
Not everybody, but I'm okay with that.
Some of them have challenged.
Okay, Mr. So-and-so has submitted that. Mr. Advocate General Mr. D. Sekya is supposed to argue the matter, however, he is busy in some other court, therefore nothing may be done. This in the month of August.
It can be in the next week also, we can. There's short time seeking them for a request for next week, my lord, because we're this.
Will go. Yes.
Highly obliged.
Item 16.
May I pray for any specific date on August, because then it helps us in.
August में registration लेना date अभी क्या specific date है?
May please, Your Lordship. In this matter, Lordship will kindly see order dated 4/6/2024, by which my lord, Your Lordship was pleased to request the Honorable Learned AG to assist the court, since we have challenged the rule herein.
Lordship has heard the prayer made in the earlier case, Lordship. However, Lordship, I am ready with the case if Lordship permits, Lordship, as additionally as the Lordship, I can appear.
On your behalf, this request was made last time.
No, Lord,
Mr. D. Sekya, then Mr. Pinayak accepted. Mr. D. Sekya, then Advocate General Rizien, is not able to argue the matter today, in the month of August.
obliged.
Item 18,
Much obliged.
May I please salute, sir? My Lordship, possible for the time being, Mr. Dinath is on, let's see, for number 4, my Lordship.
Who is on
Mr.
that?
Dinath. Dinath, Senior Commander.
Well, let it be some other day, Milord, because I'm also having some other matter.
August, at the request of the council of party, matter in August.
Obliged, my Lordship.
item 22 and 23.
Next time, national woman.
I've got clarity. In fact, we made a short note on what the two inquiries and corroboration independently are sought by your lordship. I'm just handing it to. Oh, yes. Oh, good. May I give it? Confession made before two inquiries. Three-member committee furnished report on 2nd of April 2014, page 478. Findings are at page 483. Diganta Halloy responded in the first rate appeal, examined by the committee on 26th of March 2014, and at Q&A number 11 admits that party lost rupees 1.65 lakhs on EMD, and so copper cable worth rupees 1.7 lakh, given as jointly decided with P. Borough, which is the respondent in the other writ. Pankaj Borough, respondent in writ appeal number so-and-so, the second one, examined on 26th of March 2014. Q&A number 6 and 7 admits that loading was carried out at SS3 point and he was there. Q&A number 15 records that only he and Diganta Halloy, that's the other respondent, were present on that day. Q&A number 26 admits that identification of cables was done by him, being warehouse in charge. That's very important. Then vigilance inquiry. Diganta Halloy, examined on 3rd of April 2014, page 36 at pages 38 and 39, gives explanation in the course of admission as to reason for giving unauctioned goods. Page 41 and 10th of April 2014 reiterates earlier reasons with further details in Q&A number 3. He, along with Pankaj Borough and the customer, identified the unauctioned cable to be lifted. Pankaj Borough examined on 4th of April.
Customer means?
The customer means the successful bidder.
Yes.
No, that's our third bullet point. Second, Pankaj Borough, examined on 4th of April 2014, was confronted in Q&A number 18 with the statement of Diganta Halloy also implicating him in the admission. His answer was that he was aware of this issue of compensating the customer, but he did not agree with Diganta Halloy. Charges were framed against Pankaj Borough on the basis of confession by Diganta Halloy. He did not refute or disprove the distance himself from them. Now the corroboration. The admission made by Diganta Halloy on 3rd of April 2014 was verified by a physical inspection and inventory of the cables on 9th of April 2014, where 685 meters of cable, serial number 24, was found missing. Email dated 4th of March 2014 from successful bidder saying wrongly quoted price for lot number 1 was withdrawing from a successful bid, tallies with explanation offered by Diganta Halloy. Then different description of cables. Well, for the purposes of CISF requisition and gate pass, different description are given.
While granting approval for auction, logbook entry for transfer of fire damaged goods, the reference is to fire damaged or burnt cable. However, in the request for deputation of CISF official as witness for loading of auction material, the description was of cut damaged cables. Now, statement of crane operators were recorded on 26th of March 2014 that on 15th of March 2014, he loaded 2 big cables from inside the warehouse as per the advice and in the presence of both the respondents. Now, reference to the 2 separate inquiries has been set out in the additional affidavit. Paragraphs 11 to 15 of the affidavit refers to statements given to vigilance officers, and paragraph 16 and 17 of the affidavits relate to inquiry by 3-member departmental committee. So the additional affidavit which we filed. So this is one of the sequence in terms of, if a lordship wants, I can take a lordship through the pages. Would your lordship want to go to the pages, Manoj, or is this note?
Come to this, what is your, law on the, you are relying on the law limited scope of interference in the writ petition?
Sorry, Manoj?
Limited scope.
Yes.
of interference.
Yes.
Come with that.
So, Manoj, I yesterday was showing an objects. I think I showed you lordships to which one? Chitra Venkata Ramala, 75 to SEC 557, which is at 1975 to SEC, which is page 26. 26 of the compile.
Yes.
So, Manoj, this is at page 26. The judgment is running page 26 of the compilation I gave to your lordships. Judgment compilation.
Paragraph.
2021. So, your lordships may come straight away, page 31.
Yes.
Page 31. Page 31. I'm reading for paragraph 20. The High Court all throughout treated the inquiry before the tribunal. Paragraph 20 at page 561 of the judgment, internal page.
561.
Page 30. Or
Yes.
Paragraph 20. The High Court all throughout treated the inquiry before the tribunal as a criminal prosecution. The scope of Article 226 in dealing with departmental inquiries has come up before this court. 2 propositions were laid down by this court in State of AP versus S3 Ramarao. First, there is no warrant for you to view that in considering whether a public officer is guilty of misconduct charged against him, the rule followed in criminal trials that an offence is not established unless proved by evidence beyond reasonable doubt to the satisfaction of the court must be applied. If that rule be not applied by a domestic tribunal of inquiry, the High Court in a petition under Article 226 of the Constitution is not competent to declare the order of the authorities holding a departmental inquiry invalid. The High Court is not a court of appeal under Article 226 over the decision of the authorities holding a departmental inquiry against a public servant. The court is concerned to determine whether the inquiry is held by the authority is by an authority competent in that behalf and according to the procedure prescribed in that behalf, and whether the rules of natural justice are not violated. Secondly, where there is some evidence which the authority entrusted with the duty to hold the inquiry as accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge, it is not the function of the High Court to review the evidence and arrive at an independent finding on the evidence. The High Court may interfere whether departmental authorities have held the proceedings in violation against the delinquent in a manner inconsistent with the rules of natural justice, or in violation of the statutory rules prescribing the mode of inquiry, or where the authorities have disabled themselves from reaching a fair conclusion by some considerations extraneous to the evidence and the merits of the case, or by allowing themselves to be influenced by irrelevant considerations, or where the conclusion on the very face of it is so arbitrary, so wholly arbitrary and capricious that no reasonable person could have ever arrived at that conclusion. The departmental authorities are, if the inquiry is otherwise properly held, the sole judges of facts, and if there is some legal evidence on which their finding can be based, the adequacy and reliability of that evidence is not a matter which can be permitted to be canvassed before the High Court in a proceeding for a writ under Article 226. Again, this court and Railway Board representing the Union of India, New Delhi versus Niranjan Singh, that the High Court does not interfere with the conclusion of the disciplinary inquiry unless the finding is not supported by any evidence, or it can be said that no reasonable person could have reached such a finding. In Niranjan Singh's case, this court held that the High Court exceeded its powers in interfering with the findings of the disciplinary authority on the ground that the respondent was instrumental in compelling the shutdown of an air compressor at about 8:15 a.m. on 31st of May 1956. The court said that the inquiry committee felt that the evidence of two persons that the respondent led a group of strikers and compelled them to close down the compressor could not be accepted at its face value. The general manager did not agree with the inquiry committee on that point. The general manager accepted the evidence. The court said it was open to the general manager to do so, and he was not bound by the conclusion reached by the committee. The court held that the conclusion reached by the disciplinary committee should prevail, and the High Court should not have interfered with the conclusion. Again, 23 and 24, two more paragraphs I will read. The jurisdiction to issue a writ of certiorari under Article 26 is a supervisory jurisdiction. The court exercises it not as an appellate court. The findings of fact reached by an inferior court or tribunal as a result of the appreciation of evidence are not reopened or questioned in writ proceeding. An error of law which is apparent on the face of the record can be corrected by a writ, but not an error of fact, however grave it may appear to be. In regard to a finding of fact recorded by a tribunal, a writ can be issued if it is shown that in recording the said finding, the tribunal had erroneously refused to admit admissible and material evidence, or had erroneously admitted inadmissible evidence, which has influenced the impugned finding. Again, if a finding of fact is based on no evidence, that will be regarded as an error of law which can be corrected by a writ of certiorari. A finding of fact recorded by the tribunal cannot be challenged on the ground that the relevant and material evidence adduced before the tribunal is insufficient or inadequate to sustain a finding. The adequacy or sufficiency of evidence laid on a point in the inference of fact to be drawn by the said finding are within the exclusive jurisdiction of the tribunal. See so and so. Now, paragraph 24. The High Court in the present case assessed the entire evidence and came to its conclusion. High Court was not justified to do so. Apart from that aspect, the High Court does not correct a finding of fact on the ground that the evidence is not sufficient or adequate. The evidence in the present case, which was considered by the tribunal, cannot be scanned by the High Court to justify the conclusion that there is no evidence which would justify the finding of the tribunal that the respondent did not make the journey. The respondent gave reasons for the conclusions. It is not possible for the High Court to say that no reasonable person would have arrived at these conclusions. The High Court reviewed the evidence, reassessed the evidence, and rejected the evidence as no evidence. This is precisely what the High Court, in exercising jurisdiction to issue a writ of certiorari, should not do. No. State Bank of Bikaner and Jaipur. Which one is it? Page 56. Next touch. State Bank of Bikaner and Jaipur. 2011 for SEC 584. 2011 for SEC 584. At page 56. Paragraph 7, 8, and 10 minutes.
Yes.
It is now well settled that the courts will not act as an appellate court and reassess the evidence led in the domestic inquiry, nor interfere on the ground that another view is possible on the material record. If the inquiry has been fairly and properly held and the findings are based on evidence, the question of the adequacy of the evidence or the reliable nature of the evidence will not be grounds for interfering with the findings in a departmental inquiry. Therefore, courts will not interfere with findings of fact recorded in a departmental inquiry, except where such findings are based on no evidence or where they are clearly perverse. The test to find out perversity is to see whether a tribunal acting reasonably could have arrived at such conclusion or finding on the material on record. The court will, however, interfere with the findings in disciplinary matters if principles of natural justice or statutory regulations have been violated, or if the order is found to be arbitrary, capricious, malafide, or based on extraneous considerations. Paragraph 8. When a court is considering whether the punishment of termination from service imposed upon a bank employee is shockingly excessive or disproportionate to the gravity of the proved misconduct, the loss of confidence in the employee will be an important and relevant factor.
That is in relation to bank.
Yes. Yeah. Then we're 10. We don't need to go into that. So there's an acquittal by criminal court. Where basically one of the principles, the preponderance of probabilities and any other judgment. Then as this is far as the 283 writ appellant is concerned, I have 2-3 submissions regarding the second writ appeal, because this is the superior officer. The first, the appellant in the respondent in writ appeal 283 is the assistant manager. The appellant in the respondent in 284 is the senior materials manager. This is Pankaj Babu, who Milord said, who was party to all of these proceedings, and he was confronted with that statement.
Just come to that inquiry report.
Very good. Thank you. Inquiry report of Milord's 20th of March 2015. I will take it a look. So, inquiry report is at 20th of March 2015. In the first writ appeal is at page Milord's 140. No? 20th of March.
Page number
140. And the findings are at from 141. Your Lordship has 283 minutes. Writ appeal 283.
Writ appeal 283.
Yes, sir.
No, why 284?
Oh, well, I've been arguing from 283. Yes, sir. 283, 280. I'm sorry. Look at that. 140, let's at 141 of the finding.
You read the inquiry report from 140.
Very good. With reference to your note dated so and so on the subject, please find attached. Report on the charges level against Sri Pankaj Babu Videsh Focus notice dated so and so, and Sri Diganta Alai Videsh Focus notice dated so and so. Proceedings of the inquiry were completed in 12 regular hearings, besides a preliminary hearing held on 18th of September 2014. The final hearing was held on 6th of March 2015. 8 witnesses were produced before me, and they were examined and cross-examined in my presence by the presenting officer. Sri N.K. Bharagwa as well as Sri Pankaj Babu and Sri Diganta Alai hereafter referred to as defendant. As advised, the disciplinary proceedings were conducted simultaneously through a common proceeding. Sri Pankaj Babu and Sri Diganta Alai took the help of Sri Mintu Handik and SM Projects and Sri Kumut Saikya AM NRMT, respectively as assisting officers, after my seeking my consent for the same. The documents which were relied upon in support of the charges made against the defendant, and also other documents furnished or sought by the defendants during the initial proceeding and furnished thereof, were relied upon me by arriving at my inquiry finding. I have carefully noted the depositions made by the witnesses and the arguments put forward by the presenting officer and the defendants with due application of mine. I have arrived at my inquiry finding. The findings of the aforesaid inquiry are enclosed for your further.
Yes, now come to the
141 was the charges are set out.
Yeah.
Charges 1 to 5, Diganta Alai.
You read all this.
I'll read it. Sri Diganta Alai was functioning as chart number 1 as assistant manager commercial at NRL warehouse, was looking after all activities related to disposal, including scrap, besides supervision of receipt and issue of materials in store and preservation of materials, etc. under his supervision. While posted and functioning as assistant manager commercial NRL Numaligarh, Sri Diganta Alai dealt with the disposal of CDU fire damage weapons for the e-auction ID so and so of 17th of February 2015. The fire damage cables were kept at the designated scrap yard and located at north of road number 6, between road number 5 and 7 by Sri Diganta Halo on 15th of March 2014 in connivance with Sri Pankaj Varo, unauthorizedly had allowed Mrs. Telex to load 31.95 metric tons of cables, which was not part of the auction from other areas near the substation number 3, open yard 01 or on open yard number 04. So I may just pause here for a moment. So far, we have only focused on those copper and touch damage tables, but it as it appears, it's also from other areas also just picked up. This is what the charge number was.
What?
The fire damage articles were put in one particular place.
And the other cable was from other place and.
Other place, so that apart from that copper cable which we identified, it was lifted also from other areas, not from the designated scrapyard where the fire damage articles are.
That is what the chart is.
Yes, yes.
That is what the chart.
Yes. During the said period, charge number 2, Sri Diganta Hala had raised the request for deputation of CISF official for witness on 14th of March 2014, where he had mentioned the quantity as cut damage table 60 MT approx, although the auction was held for CDU, VDU burnt cables and no weight was taken prior to the auction. 3. Sri Diganta Hala allowed the lifting of 3 trucks of materials from NRL premises by the buyer on 15th of March 2014, which was not at all from the auction law. During dismissal of scrap, 3 trucks.
Yes.
During disposal of the scrap material on 15th of March 2014, Sri Diganta Haloy and connivance with Sri Pankaj Varo had allowed Mrs. Telex India to take away 2 coils of copper cable of length 685 meters with a book value of rupees 16.05 lakh from the open yard 01 as part of the scrap which was not part of the auction. Sri Diganta Haloy, in connivance with Sri Pankaj Varo, had pre-planned to dispose scrap on 15th of March 2014, which was an off day in NRL, to Mrs. Telex India, and issued non-auction materials as per his convenience by taking advantage of absence of other staff of warehouse. The above charges against Sri Diganta Haloy are found prejudicial to the interest of Numaligarh Refinery, which tantamount to misconduct committed by him within the meaning of Sub Rule 1, 6 and 20 or Rule 1, misconduct under Part 3, Discipline and Appeal Rules of the Conduct, Discipline and Appeal Rules 1995 for management staff of Numaligarh Refinery Limited as applicable to him. 1. Theft, forgery, fraud, embezzlement, misappropriation, dishonesty in connection with the business or property of the company or a property of another person within the premises of the company, acting in a manner prejudicial to the interests of the company. 3. Breach of rules duly notified or violation of procedures laid down in connection with the company's business. Further, he acted in a manner prejudicial to the interests of the company and contravened rules 4A, B, and C, 4C or Rule 4 of Part 2. Conduct rules or conduct discipline and appeal rules for management staff on Numaligarh Refinery Limited. Inquiry findings. Statement of witness Sri G.K. Bora, Chief Manager Project, taken on 19th of January 2015, and by Sri Himanta Minog, Senior Manager Electrical Maintenance, taken on 9th of January 2015, indicate the presence of designated scrapyard for CDU, VDU burn cables and formation of a task force to deliver the CDU, VDU burn cables to a designated scrapyard. However, both of them did not confirm whether Sri Diganta Haloy was communicated about the designated scrapyard and task force meant for the purpose. Sri Diganta Haloy has admitted that disposal was done from areas namely near the substation number 3 and open yard 04 as per his understanding. Such locations are under the purview of the scrap disposal under inquiry. In this connection, Departmental Inquiry Report 2nd of April 2030 may be referred to. In a statement of witness of Sri Nukul Bora, General Workman, taken on 23rd of January 2015, he stated that scrap materials are not sealed in one location yard. Various locations were utilized for the same. The matter of designated scrapyard for CDU, VDU cables and formation of task force to deliver the CDU, VDU cable to the designated scrapyard was also discussed and recorded in the MOMs of the relevant CDU, VDU shutdown meetings in which the participants were there from the technical functions. No documentary evidence was furnished during the proceedings specifying, identifying the location and existence of a designated scrapyard and communicating the same to Sri Diganta Haloy. Sri Diganta Haloy also stated that due to the pressure of the bidder, this is where the confession part is recorded, that due to the pressure of the bidder, he jointly with Senior Manager Materials decided to compensate the bidder by handing over old cramped twisted copper cable of around 1.5 ton lying in OI01 for a long period of time. This, as claimed by him, was due to wrong information given by the warehouse to the bidder, and the bidder was likely to forfeit IMD amounting to rupees 1.7 lakhs, 5 lakhs for the first lot. The bidder demanded warehouse to refund their EMD or compensate the loss of rupees 1.75 lakhs. However, subsequently, in his written statement of defense dated 12th of July 2014, submitted to Director Technical, Sri Diganta Haloy denied the statement, saying that this was out of mental pressure and duress of the higher officials. Statements of 04 hydro operators CISF Constable Pankaj Chaudhary, CISF Head Constable Rajiv Vora reveals that Shri Pankaj Vora and Shri Diganta Haloi had allowed the materials to be located from areas near the substation number 3, open yard and open yard number 04. Hence, the charge number serial number 1 against Shri Diganta Haloi stands partially proved. In the summary of defendant number submitted on 6th of March 2015, Shri Diganta Haloi admitted that as there was a problem with creation of gate passes at lot 3 for vehicles, therefore a rough estimate was considered and accordingly vehicles were weighed and SAP transactions were carried out for proportionate quantity. This was all done as per direction and with the information of HOD. This was evident from the fact that gate passes and invoices were authorized by HOD Shri Pankaj Vora in this case. Hence, the charge at serial number 2 above against Shri Diganta Haloi stands proved. Statement of witness by Shri G.K. Bora, Chief Engineer Projects, taken on 19th of January 2015, and Shri Hemanta Nayak, Senior Manager Electrical Maintenance, taken on 9th of January 2015, indicate the presence of designated scrapyard for CDU video burn cables and formation of a task force to deliver the CDU video burn cables to the designated scrapyard. However, both of them did not confirm whether Shri Diganta Haloi was communicated about the designated scrapyard and the task force meant for the purpose. Shri Diganta Haloi has admitted the disposal was done from areas near the substation number 3 and open yard number 04 as per his understanding. Such locations are under the purview of the scrap disposal under inquiry. In this connection, Departmental Inquiry Report dated 2nd of April 2014 will be referred to. In his statement of witness, Shri Nokal Bora, General Workman, taken on 23rd of January 2015, the seal materials are not, the scrap materials are not sealed in one location and various locations were utilized for the purpose. The matter of designated scrapyard for CDU video cables and formation of a task force to deliver the CDU video burn cables in the designated scrapyard was also discussed and recorded in the MOMs of the relevant CDU video shutdown meetings in which the participants were from the technical function. No documentary evidence was furnished during the proceedings specifically identifying the location and existence of a designated scrapyard and communicating the same to Shri Diganta Haloi. Shri Diganta Haloi also stated that due to pressure of the
Relation to this charge number 1 and the 3 is the verbatim.
So, my lord, charge number 1 is basically is the same subject. The fire damage were kept at the designated thing. If one reads, my lords, the fire.
Charge number 1 and charge number 3.
Yes.
Now the finding is verbatim in respect of both the charges.
Yes, my lords. Because my lords, the issues are also identical. I think there was a multiple. They were overlapping, my lords.
No. Charge number 3 is Diganta Haloi allowed the lifting of 3 trucks of material. Fire on itna. There is.
Which are not. So again, my lord, if your lordship sees the last part of the charge number 1 and charge number 3 is the same. Charge number 1 also, the Shri Diganta Haloi in connivance so unauthorized allowed Messrs. Telex to load 31.95 cables which are not part of the auction from other areas near substation number 3, open yard and open yard number 4. Again, charge number 3, Diganta allowed the lifting of 3 trucks of material which was not part of the auction law. So, my lords, it's actually it's overlap. It's a lot of overlap.
Yes.
Huh? The third number charge basically says it's unauctioned goods. That's it.
Yes.
See, it's overlapping. So that's why. So statements of hence the charge that stands against partially proved. Now, charge number 4 is during the disposal whether took away a book value of 16.05. The first paragraph is the one which his confession is recorded. Statements of Hydra operators and constable reveal that Shri Pankaj Vora and Shri Diganta Haloi, second paragraph I'm reading, to be loaded from open yard 01. In the now third paragraph, last paragraph, your lordship may read in that charge number 4 and bottom of the page. In the physical verification by stores at open yard number 01 on 9th of April 2040, report submitted by Shri Cooperative on 11/4 against the occurrence of the incidents on 15th of March is when indicated there was a shortage of 685 meters copper cable with tag number swings. So now, my lords, 144 over the page.
Yes, read.
Yes. A statement of witness by Shri G.K. Bora, Chief Manager Projects, taken on 19th of January 2015. Shri Hemanta, Senior Manager Electrical, taken on 9th of January 2015. By Shri Pravi Kumar Talukdar, CM Commercial, taken on 7th of January 2015. And report of SD APDCL Kamargaon Electrical Supervision dated 22nd of March 2015. Do not confirm that 2 couples of length 685 with a book value of rupees 16.05 lakhs were part of the scrap disposal on 15th of March 2014. Presenting officer in a summary of evidence of imputation of misconduct in support of the articles of charge framed against Shri Diganta Bora submitted by him, Diganta Haloi, submitted by him over email on 22nd of February, along with the exhibits mentioned herein, had taken on record during the proceedings held on 25th of February 2015, referred to photograph of the cables taken on the truck subsequently while the truck was under police custody. However, presenting officer did not disclose availability of such photographs during the mutually agreed period of disclosure of document by presenting officers, and defendants nor did he furnish any such photographs before me. If I may just pause here for a moment. What happened is subsequently when it went up on appeal, then the appellate authority redirected evidence to be led. The disciplinary authority directed fresh evidence to be led on this particular charge after furnishing the videos and the photograph, and that is how that he stood to prove. So here he's relied on the confession and the statements otherwise. So hence the charge now charge at serial number 4 above against Sri Diganta Hans has partially proved. Now, number 5, Sri Diganta Alay cited certain regions of urgency for proceeding. This is whether it was disposal, why it was disposed of on an off day. Sri Diganta Alay had cited certain regions of urgency for proceeding with disposal of scrap on 15th of March 2014, which was an off day in contravention of an e-auction in terms and condition without any approval. In his defense, he did not furnish any document containing approval for deviating from term and conditions of e-auction, nor did he furnish any reason for not seeking such document of approval from his superior before proceeding for disposal on off day. In this connection, statement of witness of Sri Aruni Prasad Chakravarti taken on 19th of January 2015 can be inferred, to where Sri Aruni Prasad Chakravarti stated that the deviations to conditions laid down in the business rules, terms and conditions for disposal of scrap rules has to be routed to the committee which originally approved the business rules, terms and conditions. In his written argument submitted by him on 6th of March 2015, he only defended his attending of duty and carrying out the disposals on an off day based on a verbal advice of HOD Sri Pankaj Bora. Hence the charge at serial number things stands proved. No.
Then what about this another person?
It will be in the other interpretation.
And where is the order, final order by the disciplinary authority?
The final order in this case, is final because it went to disciplinary authority and remand 169. Huh? 169.
169.
169.
The order of the disciplinary authority?
Yes. This is a reference to memorandum. So we enclose order dated in original, which is this is the enclosure. The order is at page 170. A memorandum, as I'm reading. Memorandum VDA reference number so dated 10th of June 2014 was issued to Sri Diganta Halay, Assistant Manager Commercial, charging him with the following misconducts under sub rule 1, 6 and 20 or rule 1, misconduct, discipline appeal rules of the conduct, discipline appeal rules for management of staff, etc. These are the charges laid out: 1, 2, 3, theft, acting in a manner prejudicial, which I've read out earlier, breach of rules. The articles of charge framed against Sri Diganta Halay were as follows. The 5 articles of charge are spelled out. Then over the page at 106, I will read. Sri Diganta Halay, I'm reading from paragraphs after paragraph 5 minutes, the second paragraph. Sri Diganta Halay submitted his written explanation VDA letter dated 12th of July 2014 in response of said memorandum, which was considered by the undersigned when it was not satisfactory. Sri Jabashish Chaudhary was appointed as inquiry officer by the undersigned to inquire into and frame charges against Sri Diganta Halay. VDA order dated so and so 5th of August 2015. Inquiry officer submitted the inquiry report dated 20th March to the undersigned along with his finding. After scrutiny of the inquiry report, after obtaining representations from Diganta Halay in the same, the undersigned VDA dated 8th of June 2014-15 had advised the inquiry officer to conduct further inquiry in charge number 4 against Diganta Halay. After further inquiry, inquiry officer submitted a report to undersigned reference so and so on 8th of July 2015. Representation also sought from Diganta Halay on this report on further inquiry. Taking both the reports into consideration, it is seen that charge numbers 2, 4, and 5 against Sri Diganta Halay have been established as true. The undersigned has carefully considered the inquiry report along with the inquiry proceeding, including the management and defense briefs and all related documents and other. After application of mind, it has been observed that full opportunity has been given to Sri Diganta Halay by the inquiry officer for defending the case by observing the principle of natural justice. The undersigned has considered representations dated 27th of April 2015 and 13th of August 2015 of Shri Diganta Alay in response to the inquiry reports provided to him, but the same was not found satisfactory in view of the seriousness and gravity of the charges proved against him. The undersigned is in agreement with the inquiry officer and accept the findings in total. The undersigned has observed that Shri Diganta Alay has conducted a very serious misconduct, and his continuance in the organization is not desirable. He requires to be given stringent exemplary punishment. Accordingly, the undersigned in terms of the powers conferred upon him with a Rule 2, Part 3, Schedule 1 of the Discipline and Appeals of the Conduct Discipline and Appeal Rules 1995 for management of staff of Numaligarh Refinery, do hereby impose the removal of penalty from service, which shall not be a disqualification for further employment with effect from 31st of March 2014 from the date of Shri Diganta Alay have been placed on suspension pending inquiry. In between, there is that order of 8th of June, if your lordships want to see where it had been remanded for fresh, which is at page, well, let's just look at it. 18th of June.
Yes,
8th of June is at page 168.
168.
Yes.
And after remand, what is the order? The report of the inquiry officer?
158, I'm sorry. 158.
150?
No. 158.
This is the further inquiry.
Further inquiry. No, this is the further inquiry. The order, the further inquiry at 158.
158 is the
Further inquiry. Because the director technical had, the disciplinary authority, who's the director technical, had directed that on charge number 4, the photographs and videos had not been proved. So had not been presented. So, my lords, if I may read, with a note reference number dated 8th of June 2015 from Director Technical on the subject, I was advised to conduct further inquiry on charge number 6 brought against Shri Pankaj Vora and charge number 4 brought against Shri Diganta Alay. This was issued as part of the Rule 621 of Discipline and Appeal Rules or Conduct Discipline and Appeal Rules for Management Staff on Numaligarh Refinery Limited. Accordingly, presenting officer with an email dated 13th of June from me was given opportunity to produce the photographs as well as other documents witnesses required pertaining to the above mentioned charge. Presenting officer furnished to me 3 copies of a DVD signed by him dated 13th of June. Signed by him, 13th of June on the face of the DVD by marker pen, containing soft copy of about 20 numbers of video clips and 6 numbers of still images pertaining to the aforesaid charges. A copy of each of the DVDs was handed over Shri Pankaj Vora and Shri Diganta Alay on the same day. That is 13th of June 2015, along with individual notices for hearing scheduled on 18th of June 2015. The findings of the aforesaid inquiry are produced below for your further needful. The findings with respect to the charge number 6 brought against Shri Pankaj Vora and charge number 4 brought against Shri Diganta Alay, based on the report dated 20th of March, are if your lordship wants me to read this because this is only a repetition, I can go over to the next page, paragraph capital B. Page 159, 155. Paragraph. The subsequent hearing was held on, I'm reading paragraph B. Subsequent hearing was held on 18th of June 2015 at 10:30 a.m. at Learning Center so-and-so, and the following were present. The presenting and defendant, etc. Proceedings of the hearing are as follows. The presenting officer displayed photographs and video clips and stated as below. The 3 trucks loaded with CDU, video, burn cables, and scrap kept under police custody were taken back to refinery premises for physical inspection, as already discussed in earlier proceedings. The entire process was seen in the video. The activities were performed in the presence of police, CISF personnel, NRS official, and other people in a transparent manner. The material which was loaded on the trucks was visible from the videos. The materials included in the truck in WBT so-and-so was also visible in the video clip. The tag number ECA-ECU 300A mentioned in the physical verification report, there where the inventory was carried out, was also visible from the video as well as still images. The name so-and-so, code number so-and-so, and price tag. Shri Pankaj Vora responded the follows. He has no knowledge regarding the 20 numbers video clips and 6 numbers of still images contained in the video sent by inquiry officer along with reference number so-and-so, dated 13th of June 2015, and he has doubts on the photographs and video clip. Some of the video clips contained in the DVD cannot be opened by him. Also, before filing his written statement, no such types of video clips and still images were given to him. Shri Diganta Alay responded as follows. The said video clips were neither part of the list of documents attached to the charge sheet dated 10th of June 2014, nor the same were part of the additional documents produced during the inquiry proceeding. Moreover, after completion of physical verification on 20th of March 2014, one expert from ACG, APDCL, Kamarga Electricity also verified some cables and made his comments in that regard on that day. In addition to above, item code is not clearable and the cable shown in the video clip appear as unusable, cut and damaged. This is as per the statement of NRL department as appearing in the video clip number so and so and as seen in the video clip number so and so. Also, any item code was not mentioned in the statements, preliminary inquiry, etc. Further, quantity of cables is in the heap of truck could not be ascertained from the heap video clip. There being no further deliberation on the matter, the hearing was closed. Based on the aforesaid finding, more particularly the photographs and video clips of the coils of cables submitted as evidence by the presenting officer, the charge number 6 against Sri Pankaj Baru and the charge number 4 against Diganta Halai transfer.
Now, this come to page 140.
Yes.
140.
Please, Manoj.
That is the inquiry report, initial inquiry report.
Yes, sir.
Wherein you said 8 witnesses were produced before me and they were examined
Yes.
and cross-examined in the presence of some. Who are those 8 witnesses?
It's at 105, I think, the list of witnesses is given. No? I showed that list to your lordships yesterday. I think it's 105 or 115. No, I'm sorry. Huh? 150. I'm sorry, Manoj.
115.
Please, Manoj.
Imputation.
115 or 160.
These 8 statements starts from which page?
Statement of imputation. Manoj, it is the statement of articles of charges along with the list of witnesses has been given. The list of it starts.
Statement of the witnesses.
Oh, your lordship wants the statements of the witnesses. Oh, have you filed it? Where is it? It's in the record. It's in the record which we had to the record. On the first day, your lordships are asked for the original record to be kept here. The record is here.
Who has asked?
Your lordship, if your lordship sees the August order of 28th of August, when the lordships had issued notice for it, the records had been asked to be kept in court, and we have put them. We can flag them if necessary. Where is it? What is it? We are carrying the record, Milad. Asana, look what? Guide us. It's my learned friend is getting it. What we can do is, when if your lordship desires, we can have those evidence partners flagged and put to your lordship, all the witnesses. And the witnesses are given as 115 and 116.
With greatest respect, my lord, if these records are to be produced, they should have given us a copy at least of whatever they're producing.
No, this is the court record. They were before the learned, they were filed before the learned single judge also. If the learned single judge had taken them, my learned friend can always inspect. In fact, when your lordships are asked the record to be kept, they could always sought inspection.
Where is the record?
My learned friend is getting it. In the meantime, I can take your lordships to the, this is the list of witnesses are given here. 105, 15.
115.
116.
Yes, list of witnesses.
And 8 witnesses. And an appeal against the disciplinary authority, Milot, the appellate authority, Milot, reduced the penalty. I see. Until the records come, my lords, can I take your lordships to the other appeal, my submission, sir, then your lordships can see this.
Other appeal?
The other appeal, my lords, well, they are Pankaj Boro. Your lordship has dealt with one so far. Yeah, my lords, this was modified, as I said to your lordships, to complete the chain on the 12th of December, 25th of January, 2016.
The evidence is more or less the same.
Evidence is the same order.
More or less the same.
Yes. Just a few more additional submissions there, my lords. That's
According to the order passed by the learned single judge,
yes.
there are the findings.
My lord, the learned single judge principally has rendered 3 findings.
Para number 13, to start with. Yes. Para number 13,
Yes.
page number, internal page 15,
Para 13.
the common judgment.
Yeah, common judgment. Your lordship says page 13.
1 5
15. I will. 15.
Para number 1, para number 1.
I come to that. Learned counsel for the parties have been heard. Pleadings available on record have been carefully perused. The records presented before the court have also been perused. Judgments cited by the bar have also been carefully taken note of. The facts which are not in dispute are that pursuant to a fire incident, but the records have also come. I know.
First, go through it.
The facts which are not disputed in the present proceedings are that pursuant to a fire incident which took place in the Numaligarh Refinery Limited Complex, the NRL authorities had decided to auction scrap materials and burnt cables in 2 lots, and for the said purposes had called for an NIT. One, Mrs. Telex India was shortlisted at the highest bidder, and accordingly the contract for lifting and disposal of the scrap materials and the burnt cables was issued to the said scrap dealer shortlisted. A reference to the approval of disposal of the CDU video scrap items is available in the pleadings dated 30th of December 2013. Reviews the background as to the decision of NRL authorities for scrap materials and burnt cables. The approval for disposal is quoted below.
Legal.
Then paragraph 14, from a perusal of the approval for disposal, it is revealed that there were 2 lots put up for disposal. Lot 1 comprising of ferrous, non-ferrous scrap items and lot 2 comprising of burnt cable. The approval of disposal notes also reveal that these 2 lots are to be disposed of as to the service provider as 1 lot. The disposal note contains the signature besides that of the writ petitioners of other competent officers of the NRL. However, these 2 lots do not specify the particulars of the items included in each of the lots. A perusal of the report of inspection of the Chief Manager Commercial, which was the precursor to the disciplinary proceeding, initiated against the petitioner is also necessary. The report clearly indicates that the 3 vehicles which were engaged in by the service provider, the H1 bidder in respect of disposal of scrap and bin materials, were physically examined by the chief.
Read some slowly.
Sorry.
Please.
Sorry.
Yes.
The report clearly indicates that the 3 vehicles which were engaged by the service provider, the H1 bidder in respect of disposal of the scrap items and burnt cable, were physically examined by the said Chief Manager Commercial. The report of the Chief Manager Commercial is extracted below. I had not shown this to you. We have not shown this to your lordship. This document we have not shown. The report of the chief. If your lordship wants.
Now come para number 16.
Very well. Basically, it says whether the missing goods, etc. On the basis of the report, the proceedings were initiated and the writ petition was placed under suspension pending inquiry. The writ petitioner, Shri Diganta Halai, was served in a memorandum of charges on 10th of June 2014, accompanied by the statement of article of charges and the statement of imputation of misconduct in support of the articles of charge. These were also accompanied by the list of documents and the list of witnesses. All of that is there. Now, paragraph 17, at page 26.
Yes.
In response to the articles of charges and statement of imputation of misconduct, in support of the articles charges, writ petitioner Shri Diganta Haloi filed his written statement of defense on 12th of July 2014 upon due extension granted by the disciplinary authority on such prayers made by the said petitioner. Thereafter, a notice of inquiry was issued by the inquiry officer on 5th of December 2014, directing the petitioner to appear before the inquiry officer on the date and time fixed mentioned therein. Similarly, the petitioner, Shri Pankaj Baro, who was also issued a suspension order on 31st of March 2014 pending departmental inquiry, he has served with a memorandum on 10th of June 2014 containing the statement of articles of charges framed against the said petitioner, along with the statement of imputation of misconduct and accompanied by the list of documents relied upon, as well as a list of witnesses which are extracted below. Then I will now come
Page 34.
page 34, paragraph 19. The writ petitioner, Shri Pankaj Baro, thereafter submitted a written statement of defense on 23rd of July 2014 in response to the charges leveled against the petitioner. Notice of inquiry was served on Shri Pankaj Baro on 5th of August 2014, and the notice of inquiry was also issued by the inquiry officer directing the petitioner to appear for the date and time mentioned in the said notice. The inquiry report in respect of the writ petitioner, Shri Ganta Hale, was submitted on 9th of April 2014, whereby out of the 5 charges against the writ petitioner, charges 1, 2, and 3 were found to be partially proved, and charge number 5 was found to be proved. Similarly, the inquiry report in respect to Shri Pankaj Baro was submitted on 20th of March 2015 by the inquiry officer, wherein charges 1, 2, and 5 were found to be proved by the inquiry officer, and charges numbers 3, 4, and 6 were found to be partially proved. On the basis of these findings, the disciplinary inquiry imposed a punishment of removal from service, which should be not be treated to be a disqualification for further employment. Subsequently, the appellate authority modified the penalty imposed to that of compulsory retirement, which was also sustained by the second appellate authority. It is at the outset, it is necessary to record that none of the writ petitions have raised any dispute regarding the competence of the disciplinary authority and or the appellate authority, as well as the inquiry officer and the presenting officer initiating the conduct and or conducting the inquiry, as well as the imposition of the penalty on the basis of the inquiry report. The dispute in the present writ petition is regard to the manager appreciation of evidence in a departmental inquiry with regard to the charges leveled against the petitioner. So the dispute was only regarding the appreciation of evidence, the manager. More particularly, in respect of the documents in electronic form, namely the DVDs containing the video clips and the photographs which were supplied to the inquiry officer, on further inquiry in the materials directed to be conducted by the disciplinary authority. Before embarking to decide on the question of correctness of the inquiries conducted and the procedure follows as had been laid down under the rules, it would be necessary to refer to the rules, namely the Numaligarh Refinery Limited Conduct and Discipline Appeal Rules for the management staff. Misconduct has been described under Rule 1 of Part 3. There are as many as 42 instances cited which are considered to be misconduct under the said rule. Under Rule 2 of penalties, there are primarily 2 penalties prescribed, namely one minor penalty comprising of censure or warning and the major penalties comprising the following. That's the setup. Paragraph 22. What has been imposed is the ENFO, removal from service was from service which shall not be a disqualification for further employment is the final penalty which is compulsory. Oh, that's come later on. The procedure for imposing
Compulsory retirement is not the.
yes, he's not because I think because the mistake is that this was because original rules and this came by a corrigendum later on 8th of June 2015. Your Lordship will recall. What I showed to your Lordships yesterday.
You mean to say that the learned single they just quoted this? This from the unamended.
Yes.
Yes. In the amended rules, this compulsory retirement was incorporated in the year 2011.
2011.
Yes.
The procedure for imposing penalty is described under Rule 6.7 of the Numaligarh Refinery Limited Conduct, Discipline and Appeal Rules for Management Staff. Under Rule 6 of the Numaligarh Refinery Limited Conduct, Discipline and Appeal Rules of Management Staff, it is provided that after definite and distinct charges are framed on the basis of the allegation against the management staff by the disciplinary authority, the charges together with the list of allegations accompanied by the list of documents and the witnesses shall be communicated in writing to the management staff, who shall be required to submit the written statement of defense within a period of 15 days on whether he admits or denies all any of the charges. Upon receipt of the written statement, an inquiry may be held by inquiring officer, so appointed by the disciplinary authority, unless the charges are accepted by the authority in his written statement. Upon inquiry officer and presenting officer being appointed, the inquiry proceedings are to be completed as per the procedure described. The rules permit the management staff to take assistance of any other management staff of the company or wife or any public servant, but not a legal practitioner, unless the case is presented by a legal practitioner or a prosecuting officer of the Central Bureau of Investigation or governmental office. On the date fixed by the inquiry officer, management staff shall not appear before the inquiry officer at the time shall appear before the inquiry officer at the time and place specified in the notice, and the inquiry officer shall ask the management staff whether he pleads guilty or not, or has any defense to make. If the management staff does not plead guilty, the inquiry officer shall adjourn the matter to a later date, not exceeding 7 days, after which the management staff may be permitted to inspect the document, submit a list of additional documents to be supplied, with copies of statements of witnesses, etc. Under Rule 21 of the Discipline and Appeal Rules, the disciplinary authority, for reasons to be recorded in writing, is empowered to remit the case to the inquiring authority for fresh or further inquiry, and the inquiry authority shall thereupon proceed to hold further inquiry proceedings, further inquiry according to the provisions of law. Now, this is where the mistake begins to happen. Rule 9 provides for premature retirement of staff. Under Rule 9, premature retirement of staff is permissible where any employee attains the age of 50 years and is considered to be medically unfit, inefficient, or of doubtful integrity. The criteria for judging medical unfitness, inefficiency, or the doubtful integrity of the management staff proposed to be prematurely retired is prescribed under Rule 9(2). Where all these rules are set up. Then I come to page 45, para 26.
Yes.
The inquiry, which was initially conducted in respect of the writ petitioners, resulted in an inquiry report where charges 1 to 4 were found to be partially proved, and charge number 5 to be proved in respect to the writ petitioner and writ petition number so Diganta Haloi. And so far as writ petition number Pankaj Paru is concerned, the finding in respect of charge numbers 1, 2, and 5 were found to be proved, and charge numbers 3, 4, and 6 were found to be partially proved. What penalty were maintained of these findings to be imposed by the disciplinary authority was not arrived at by the disciplinary authority on the basis of the inquiry report submitted by the inquiry officer. However, under the provisions of Rule 621 of the Discipline and Appeal Rules, a further inquiry was conducted on the basis of the materials which were available on a DVD comprising of 20 numbers of video clips and 6 numbers of still images or photographs. Upon such directions, the disciplinary authorities of further inquiries conducted, and thereupon the inquiry officer returning a finding that charge number 4 in respect to the writ petition, Diganta Haloi, which was earlier found to be partially proved, stood proved, and charge number 6 in respect to the writ petitioner, Pankaj Paru, which was earlier partially proved, stood fully proved. From perusal of materials before this court, these video clips and photographs contained in the DVD is seen to be in the possession of the presenting officer as per the first report of the inquiry officer. However, since these DVD containing the video clips and still photographs were not presented by the presenting officer during the process of exchange of document, the inquiry officer did not permit the presenting officer to present the DVD. However, in view of the specific order passed by the disciplinary authority, further inquiry is conducted, and these DVDs containing the video clips and the still photographs were presented during the course of the inquiry. And on that basis, the charge number 4 in respect of the writ petitioner, Shri Diganta Haloi, and charge number 6 in respect of the writ petitioner, Shri Pankaj Paru, was found to be proved. Consequently, the disciplinary authority imposed a penalty of removal from service without disqualification for further appointment. The question is as to how evidence to be led in a departmental proceedings has been clearly laid down by the Apex Court in a series of judgments. It is apposite to examine the law laid down by the Apex Court in this regard. The Apex Court in Roop Singh Negi has stated that departmental proceedings is a quasi-judicial proceeding. The inquiry officer found a quasi-judicial function. The charges leveled against the delinquent officer must be found to have been proved. The inquiry officer has a duty to arrive at a finding upon taking into consideration the materials brought on record by the party. In the context of the facts of Roop Singh Negi, it was held that the evidence collected during the investigation of the investigating officer against the accused by itself could not be treated to be evidence in disciplinary proceeding. No witness was cross-examined to prove the said document. Examined to prove the said document. The management witness merely presented the documents and did not prove the contents thereof. The Apex Court further went on to hold in the facts of Roop Singh Negi that the only basic evidence on which reliance was placed by the inquiry officer was the purported confession made by the appellant before the police. It was held that on the basis of the contention of the appellant thereon, he was forced to sign to the said confession as in the police station. The Apex Court held that the appellant, being an employee of the bank, said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence and there was no indirect evidence. Referring to earlier precedent rendered, the Apex Court in Roop Singh Negi held that the materials required to be brought on record pointing out to the guilt are required to be proved. A decision must be arrived at some evidence which is legally admissible. The Apex Court held that the provisions of the Evidence Act may not be strictly applicable in a departmental proceeding, but the principles of natural justice are. It was held in the facts of the case that the inferences drawn by the inquiry officer were not supported by any evidence. The Apex Court held that the suspicion as is well known, however high, under no circumstance shall be a substitute for legal proof. Coming to the present proceedings, the imposition of penalty on the petitioners on the basis of the recommendation of the inquiry officer and the further inquiry conducted pursuant to the direction of the disciplinary inquiry. The DVDs containing the video clips and the still photographs were used as material to show the purported presence of 2 separate coils of large dimensions present in the third charge. What is also noticed from the inquiry report and other relevant documents that these video clips were taken on the lorry or the truck was under the police custody. What is, however, not evidence from the pleadings available in the records placed before the court is the author of the person taking these video clips and still photographs, and as to how these photographs drive home the charge that the petitioners are guilty of permitting the service provider H1 bidder of the scraps to take away these 2 coils of large dimensions, which were not part of Lot 1 and Lot 2. The records which are available for the court does not reflect as to whether these 2 coils of large dimensions can be treated to be scrap or useless materials or whether they were fresh or usable ones. No such finding or report on these 2 coils are available or placed before this court to support the conclusions arrived at by the inquiry officer. Even if the DVDs containing the video clippings and still photographs are taken on face value, even there must be some evidence to arrive at the conclusion that these 2 coils of large dimensions are not part of the lot which were auctioned, and that the same were unauthorizedly permitted by the petitioners to be lifted by the petitioners to be lifted by the service provider. A reference is made to a purported confession by the petitioner Shri Diganta Haloi that these cables were permitted to be lifted by the service provider in order to compensate him because of a shortfall of the total weightage of the goods to be auctioned as per the auction. The said confession was, however, subsequently withdrawn by the petitioner on the ground that the same was issued upon a duress by higher officials of the NRL. Under such circumstances, finding arrived at by the inquiry officer in the further inquiry is not based on any material which are shown to be present in the support of the charges brought against the petitioner. Further, no material is placed before the court alternatively nor any cogent material to suggest that the findings arrived at by the inquiry officer or his first inquiry report submitted in the disciplinary inquiry have been accepted to impose the penalty of removal from service by the disciplinary authority. What transpires from the records and materials placed before the court is that the imposition of punishment or removal from service was imposed by the disciplinary authority on the findings arrived at by the inquiry officer in the subsequent and or further inquiry conducted on the basis of the DVDs supplies as material. Coming to the question of admissibility, are the DVDs in evidence a reference to section 65A and B of the Evidence Act is necessary to be referred to. Section 65A and B is prescribed as under. Now come to paragraph 31, page 51. The provisions of the Evidence Act make it abundantly clear that any document in electronic form can be considered to be evidence only if the same is presented in the manner prescribed under section 65 capital A and 65 capital B of the Evidence Act. The question with regard to admissibility of electronic record as primary and secondary evidence was discussed by the Honorable Court and Anwar PV versus PK Bashir and others reported in 2014-10 SCC 473. The Apex Court, while examining a matter pertaining to corrupt practice under the Representation of People's Act, had the occasion to consider the admissibility of electronic record as documentary evidence under the Evidence Act. The Apex Court held that the electronic record provided for inspection of the court is documentary evidence under Section 3 of the Evidence Act 1872. Any documentary evidence by way of any electronic record under the Evidence Act in view of Section 59 and 65A can be proved only in accordance with the procedure prescribed under Section 65 capital B of the Evidence Act 1872. The Apex Court held that the purpose of these provisions is to sanctify secondary evidence in electronic form rendered by a computer. The very admissibility of electronic record, which is called as computer output, depends on the 4 conditions prescribed under Section 65 capital B2 of the Evidence Act 1872. The Apex Court held that only if electronic record is duly produced in terms of Section 65 capital B of the Evidence Act would the question arise as to the genuineness thereof, and in the situation resort to Section 45A of the Evidence Act 1872, opinion of examiner of electronic evidence can be sought for. It was held that Evidence Act does not contemplate or permit the proof of an electronic record by oral evidence if requirements under Section 65B of the Evidence Act are not complied with as the law stands in India. It was held that proof of electronic record is a special provision introduced by Information Technology 2000 Act 2000, amending various provisions under the Evidence Act. The very caption of Section 65A of the Evidence Act, read with Section 59A of this and 65B of the Evidence Act, thereof is sufficient to hold. The special provisions on evidence relating to electronic record shall be governed by procedure prescribed under Section 65B of the Evidence Act. That is a complete cone itself. Being a special law, the general law under Section 63 and 65 Act of the Evidence Act has to yield. Generally, they are specialibus non-derogant. The special law shall always prevail over the general law. Hence, Section 63 and 65 of the Evidence Act have no application in the case of secondary evidence by way of electronic record, as the same is wholly governed by Section 65A and 65B of the Evidence Act. An electronic record by way of secondary evidence shall not be emitted as evidence unless the requirements of Section 65B are satisfied. Thus, in the case of CD, VCD, the same shall be accompanied by a certificate in terms of 65B of the Evidence Act, obtained at the time of taking the documents, without which the secondary evidence pertaining to that electronic record is inadmissible. This judgment of the apex court subsequently came to be reconsidered by the apex court in Arjun Pandit Rao Kotkar versus Kailash Kushan Rao Gorantyar and others reported in so and so. The apex court, while considering the judgment along with the previous judgment of the apex court rendered in Shafi and Mehmed reported in so and so, to the effect that section 65A and 65B are the complete code on the subject, and the requirements of a section 65B being procedural can be relaxed by the court wherever the interest of justice show justifies was overruled, and the judgment of the apex court in Anwar PV was upheld with the clarification in the last sentence of paragraph 24 of the judgment rendered in Anwar PK. Under such circumstances now no longer res integra. The documents in electronic form if required to be proved must be in the procedure prescribed under section 65A and 65B of the Evidence Act, juxtaposed with the law laid down by the central government by the apex court. The facts in the present proceeding reveal that no such requirement of law under 65A and 65B of the Evidence Act was followed by the respondent authority. During the further inquiry in respect of charge number 4, insofar as Diganta is concerned, and charge number 6, as far as Pankaj Vora is concerned, by the inquiry officer on the basis of the DVDs presented by the presenting officer as per the direction of the disciplinary authority. There is no material to suggest that a certificate of the author, as required under section 65B of the Evidence Act, was brought in evidence and proved, nor are there any material to suggest that the author was examined in person during the further hearing conduct. Under such circumstances, and in view of the law clearly stated above, the DVDs containing the video clips and the still photographs which were the basis of further inquiry are now considered to have been proved in evidence as per the procedure prescribed under section 65A and 65B of the Evidence Act, read with the findings of the apex court in Anwar PK, followed in the subsequent judgment of Arjun Pandit Rao Kotkar, as discussed above. That being the position, it will have to be held that the findings of the inquiry officer and the further inquiry conducted in respect of the DVDs are not sustainable in law. The DVD contents of the DVD cannot help to have been proved in evidence which is acceptable in law as per the procedure prescribed under section 65A and capital A and capital B of the Evidence Act 1872. Consequently, the findings arrived at by the inquiry officer and the further inquiry are held to be based on
For our. Termination is down.
Is it that witnesses?
Yes, madam, they are there. Is your flag? May I just have? Flag, you flag. All of them are flag.
One.
Yes. No, my lords, I've completed one appellant. The other appellant, there are only 3 point submissions I have to make. The respondent, I'm sorry, my lords. As far as the Pankaj Boro is concerned, who's the respondent number 284, because the confession of, in fact, the confession of Diganta Hale qua him was also put in the framing of, in the charge itself, itself is a charge. He has not denied or denied it in any manner. One. Two, my lords, as far as there is as far as your lordship return to the judgment compilation of item 7, as far as how co-delinquent confession or admission binds at page 34, my lords, your lordship. How co-delinquent's confession binds, my lords, page 34. It's a 2-page order, my lords. Paragraph 3, my lords. 2 grounds have been pressed for consideration in the High Court and reiterated in the appeal. The main ground was that the report of the preliminary inquiry conducted against him before initiating departmental inquiry was not supplied to him, therefore it is violative of the principles of natural justice. The High Court has rejected this contention in our view quite rightly. The preliminary report is only to decide and assess whether it would be necessary to take any disciplinary action against the delinquent officer, and it does not form any foundation for passing the order of dismissal against the employee. The High Court also found as a fact that all the statements of persons that formed the basis for the report recorded during the preliminary inquiry was supplied to the delinquent officer. It was then contended that one of the constables, namely Alai Ram, was a co-accused, was also charged along with the appellant and his evidence was taken into consideration in deciding against the appellant, which is inadmissible in evidence. In a departmental inquiry, the question whether or not any delinquent officer is a co-accused with the other does not arise. That will arise in a prosecution laid for an officer under the IPC or Prevention of Corruption Act. The evidence recorded in the departmental inquiry stricto sensu is not evidence as per the provisions of the Evidence Act 1872. Therefore, the statement of Palairam also found the part of the record which will be taken into account in judging the misconduct against the appellant. The Inspector General had stated that even if that evidence was excluded from consideration, there were other sufficient evidence to come to the conclusion that the appellant had taken illegal gratification of the organizer of the claim. So, the statement also formed part of the record which could be taken into account in judging the misconduct. That is one of the important ones. And the last submission in this regard is that the physical that in the physical verification of the cables which followed, the corroboration of whatever they had done was one of the these are the 3. I'm grateful. Okay.
Yes.
I appear in 283 for the petitioner respondent. Diganta. Before I take your lordship through the papers, in this particular matter, not only are the correct and complete facts important, it's also the sequence of events. So before I take your lordship through the papers, may I just briefly summarize what really happened? So there was this fire incident where there were a lot of damaged cables. Now, these were
This incident took place when? This fire incident took place when?
date of the incident.
January 2013.
Huh?
May 2013.
2030.
May 2000.
May 2013. Now, as soon as these cables got destroyed in the fire, there was and it was a massive incident. Now, those cables had to be not only removed, they had to be replaced. So that exercise took place. These cables were dumped. Now, they say in the focus that it was dumped at one particular place. Now, that I'll come a little later. Now, after several months, a decision is taken. This is in connection with the insurance claim, etc. They find that they are not going to be able to recover the entire amount from insurance. So they decide to dispose of this scrap. Now, once that decision took place, there was an approval of that decision. And that approval will demonstrate that the damaged cables were never weighed. That is one very vital fact in this. An auction takes place in two lots, ferrous and non-ferrous, scrap, basically scrap material. In the auction, there was one party identified as the highest bidder. He is supposed to pick up the stuff on payment. Now that exercise takes place. As I proceed, I will point out from the inquiry itself that when Diganta Haloy was entrusted with this responsibility, it was never pointed out to him at any stage that these are the areas where the scrap material is lying. Now, I, along with my senior officer, we undertake this exercise. 3 trucks are loaded. Now, the problem starts here. If your lordship will, I'll again point out from the documents here. There was a complaint by some media persons and a students' organization. There's a reason behind that, my lord. If your lordship, just to digress a little bit, my lord, the Chief Justice will recall, very recently I had appeared on behalf of ONGC in a matter where we had to, under public pressure, we had to change certain terms of the tender itself. The reason is very simple, my lord. These oil establishments that are there in Upper Assam, there is always a demand for local employment, and whenever the contract is, that aside. Now, these trucks are seized, brought back to the NRL campus. They start unloading. Truck 1, truck 2, there's no problem. They find that these are actually scrap material. Even the
burnt cables.
Burnt cable. Now, so far as the third truck is concerned, after unloading a substantial amount, right at the bottom, they find 2 bundles of cables. And these are the 2 bundles of cables. And the description, as will emerge from the preliminary inquiries, is that 2 bundles of cables of large dimension. That is all that is said about the cables. The first inspection is conducted when the trucks are seized. The first inspection is conducted by a team of not only officers of NRL. There is a magistrate present, police is present, and most importantly, as an expert, APDCL officers are called, because the issue is regarding cables. The APDCL would be the appropriate authority. So APDCL people are also present. Inspection takes place. Thereafter, this is one very vital fact. Your lordship will find a very elaborate list of dates that have been submitted by the appellant. One of the most vital facts does not find mention in this. APDCL submits a report. The magistrate, the authorities present there at the first verification, they say that it is not possible to verify like this with the naked eye. So this needs further examination. And this law is given to the APDCL authority. The APDCL authorities submit a report that we have examined, and these are scrap materials only. I'll
Note that evidence there.
I'll place that. It is part of the records. It is there in their appeal, but it does not find mention in the list of dates.
You know, if it's a scrap material, okay, it's a scrap material, but is the burnt cables or not?
It's not just burnt cable.
It is, the difficult, as I proceed, I'll explain the problem.
As per the case of.
There are ferrous,
As per the case of.
Ferrous, non-ferrous,
Certain
and burnt.
burnt cable were placed at a particular place, suppose place A. Place A was was auctioned. The successful bidder was supposed to lift that, only that burnt cable. But later on, it was found that some other material, though maybe scrap material, which was not part of the auction property, was also brought along with that or in the trucks, loaded in the truck, and that is in connivance with you. Coupled with that, during the course of that, those two inquiry, vigilance inquiry or departmental inquiry, you confessed, okay, yes, we allowed him to take this scrap material to make his loss good for whatever reason or what. This is what
that is what is the charge.
then they also got this verification and they found that yes, 685 meters or something that is missing, or there is a variance between that, whatever the physical verification variance was found. This is what they sustained. Now the question is, so far as regarding this video clips and whatever it may be, they were allowed later on. But on the basis of the other material, which is already available on record, whether the charges against you are proved or not.
Absolutely, absolutely, precisely. To proceed further, now they first, at the first instance, after this physical verification takes place, after APDCL submits the report, they constitute a 3-member committee, departmental committee. This is in March 2014. To be precise, I think it is 22nd, around 22nd or 23rd of March, the committee gets constituted. My statement is taken on 26th of March, where they say that I have confessed. That is in a preliminary inquiry before the
two statements.
Yes, ma'am.
One before the vigilance and another before the this
3-member committee.
3-member committee.
Right. Now, this committee, this 3-member committee also submitted a report. This is all in the nature of a preliminary inquiry. This is even before the proceedings actually started.
Initiation of the disciplinary proceedings, this was fact finding in.
Exactly. Now, after this, the 3-member committee submitted its report on 2nd of April. Thereafter, the vigilance inquiry, second round of fact-finding inquiry or preliminary inquiry took place. And there also, they say that I have confessed. I'll place all that. After all this, on 9th of April, yesterday, my learned friend pointed out the physical verification chart where it has been recorded that 685 meters of cable is missing. This, the date is very relevant. This takes place, the seizure is on 20th of March. This document, physical verification, is of 9th of April, after almost 20 days. Thereafter, ultimately in the month of June, 2 months thereafter, the proceeding gets initiated. There are 5 charges. And I submit my written statement of defense. Thereafter, evidence is taken. Ultimately, the inquiry report gets submitted. Once the inquiry report gets submitted, the disciplinary authority finds that based on these, because most of the charges, important charges, are partially proved, he realizes that based on this, I cannot impose a major penalty. So therefore, what he does is further inquiry. He calls it further inquiry. Based on what? I will again place those materials. In the first inquiry itself, an attempt was made at a very belated stage to bring in those DVDs and photographs. That was refused by the inquiry officer and by recording reasons. Based on the same set of evidence, a second inquiry takes place. And in this second inquiry,
In relation to one charge.
one charge number 4, so far as I am concerned. Here, again, the inquiry officer records certain findings. And what the conclusion he derives, I will again point that out, has no correlation with the findings actually recorded. Now, based on that, he says that it's proved. Ultimately, that leads to the penalty initially of removal that gets reduced in appeal to compulsory retirement. That is how the matter came up before your lordship. Now, let us, my lord, go through the documents. First, if your lordship will come to the original approval before the auction, that is at page 100. In fact, my lord, page 100 is the approval for disposal of
Yes.
CDU fire damaged items. Now, first is the background.
Yes.
One fire incident took place May 13 at CDU unit. As per procedure, insurance claim was lodged by finance to the insurance company. While finalizing our claim, the insurance company will adjust the salvage value of the damaged materials. Hence, we get the salvage value of the declared fire damaged items. Finance has requested warehouse to arrange for disposal of the damaged scrap items generated due to this fire incident. If your lordship will kindly note this, madam. Damaged scrap items. The scrap materials consisting ferrous and non-ferrous metal items. Your lordship will kindly mark this. An impression was sought to be given that it is only burnt cables. It is not so.
No, two parts.
Ferrous and non-ferrous metal
And
items.
including burnt cable.
Burnt cable is one of the components. Including burnt cables generated due to the above fire incident are dumped at scrapyard and kept in separate lot. As the repairing jobs were taken up on war footing basis and simultaneously housekeeping was to be maintained, including site clearance from safety point of view, scrap materials were shifted to scrapyard even in night hours. Next sentence is very important. As weighing was not done, an evaluation of weight by segregating items by engaging manpower, lifting equipment, tractor, trailer, and weighing will incur a substantial cost. These items are proposed to be auctioned in lots, that is ferrous and non-ferrous metals and burnt cables. The first important fact in this whole thing is that this scrap material was never weighed. How it is relevant, I'll come to that a little later. Now, this is how the approval was granted. Once the approval was granted, the auction takes place. That I'm not troubling your lordship. And the seizure takes place. And what happens after the seizure is at page 104.
Now come to this total quantity in lot.
Yes, sir.
Here, page number 100.
My lord.
Total quantity of lot. Ferrous and non-ferrous scrap items.
And
lot 1.
yes.
And lot 2 is burnt cable.
My lord. So both are there.
The two lots.
Two lots.
One is the ferrous and non-ferrous scrap items and another is burnt cable. This is identical.
My lord. Now, once the seizure takes place and the trucks are brought, this is what transpires, man. This is on 20th of March, page 104. Report on the inspection of the fire damaged cables carried out inside the refinery area on 20th March 2014. First paragraph will indicate that it was on the basis of a complaint by media and some local unit of a student organization. Now, if your lordship will kindly come to para 4. The unloading of the first and the second truck took more than 3 hours. The unloaded cables were inspected by the police, the magistrate, representatives of Assam State Electricity Board, complainants and technical persons from the instrumentation department, electrical department of NRL. After examination of the cables, the technical persons of NRL certified that the same were not usable in refinery. Reasons being the cables were either damaged, deformed, or short of length. The complainants stated that the tender was for so-and-so burnt cables, but the cables did not look burnt. The technical persons of NRL stated that they are not aware of the tender, but reiterated that the cables on this truck were scrapped. The views of the employees of Assam State Electricity Board, who were brought as a neutral inspection agency, were not known, but it was heard that they were unable to give any comment on the cable since they had not brought any instruments with them. Police took statements from concerned so-and-so of the unloaded truck was taken. Unloading of third truck started in a similar fashion. After unloading almost the whole truck, at the bottom, there were 2 coils of cables of quite large dimension. Your Lordship will kindly note this. So even with respect to the third truck, they do not have any problem. It is only towards the bottom of the truck, they find these 2 cables. And that is where the entire dispute revolves on. On seeing these cables, the complainants insisted that these were new cables. Further, they insisted that these cables should not be unloaded as the crane may cause some damage to the cables, and taking this excuse, NRL technical persons will declare the cables as not acceptable. Next, these 2 coils of cables were inspected on the truck itself by the police, the magistrate, complainants, and technical persons of NRL. The magistrate ordered for sealing of these cables for further testing. So now this further testing takes place by APDCL, and that your Lordship will find at page 108.
Yes.
Your Lordship will kindly note the subject. Verification of electrical materials scheme 108. Subject, verification of electrical materials cables of loaded vehicle number as follows. All the 3 vehicles, these are taken into account. I have the honor to inform you that as per your instruction, undersigned visited Numaligarh Refinery Limited to inspect the materials on 23/2014. And after unloading of the materials which were loaded in the above mentioned truck in the storeyard of NRL, in presence of the circle officer, so-and-so police staff of Numaligarh Police Outpost and NRL staff, in that case, it was found that the different type of assorted sizes, cut pieces of LT and HT cables, which are not in serviceable condition and also not, it should have been suitable for any purpose. So after my inspection, I consider all the materials as condemned unserviceable cables and scrap only. Now, this report comes. This is, my lord, in fact, marked to the NRL also, if your Lordship will see this. Now comes the first 3-member committee. And there, my statement is in the additional affidavit filed by them. This is their sheet anchor, my lord. Page 472. The additional affidavit filed by them.
Yes.
It starts at page 472. And the so-called admission of my guilt is at question number 11. Party EMD lost 1.65 lakhs approx and requested to consider some compensation personally. So copper cable of rupees 1.75, about 2 metric tons. Your Lordship will kindly note this. About 2 metric tons was given as jointly decided by with P. Borough. This has a relevance, the weight. Now, this 3-member committee submits a report. Just one portion of the report was placed. The other relevant portion, if your Lordship will kindly, the report is in the same additional affidavit at page 478. what was placed yesterday by my learned friend is at page 483. This serial number 8 is what was placed before your lordship yesterday. Both Sri Pankaj Boro and Diganto Halo accept the fact that it was illegal to lift cables from warehouse area. As per Diganto Halo, it was done in discussion with Pankaj Boro. However, Pankaj Boro declines that. Sri Pankaj Boro informed that he is not aware of cable loading from warehouse area, but it was found that during the loading from warehouse area, Sri Boro was present in his warehouse, etc. This portion was read out. Now, if your lordship will kindly come back by a page 482. There are several other things which are relevant in this report. Two, I am reading out just two of them. See, right in the middle, your lordship will find inference of the committee, serial number 1. There is no defined procedure manual for disposal of scrap. The procedure note handed over to the committee was only for handling the business process in SAP. Next, serial number 3. Single order for sale of 2 lots, that is lot 1 for metal scrap and lot 2 for burnt cables, was under process for placement of order on Messrs. Steelex. Messrs. Steelex backed out from lifting lot number 1 before the placement of delivery order. Committee feels that it was improper to allow the party to lift 1 lot when he backed out from the lifting of the other lot after becoming H1. So these are defects in the system that were found. And in fact, there are at page 483, your lordship will find down below, there are several recommendations for rectifying the system. So there was no proper system in place for lifting of scrap.
So that's why only maybe you have taken advantage of this. That there is no proper system, so you can.
So that has to be established. With greatest respect, there has to be very clear and definite charges framed. And I have to be found guilty. It cannot be a case where there is no evidence and you rely on random things to implicate me.
That is what we are asking.
So that
apart from that cities and all, can you demonstrate that?
Yes, that is where I am
no
coming.
Other evidence is available on record
Absolutely.
to bring the charges home.
I'm just pointing out the basic facts, my lord. How thereafter I'll come to that. Now, my lord, again, vigilance conducts. They are also identical statement. In fact, there I say that it is 1.5 tons approx. So, assuming it can be treated to be an admission on my part, it is either 2 tons, somewhere between 1.5 and 2 tons. Now, and again, I'm not troubling your lordship with that. It was pointed out that Pankaj Boro ultimately denied that I had reviewed. Ultimately, on 9th of April, this physical verification they do, that your lordship will find at page 40 of the first volume. There are 2 important things, madam. Page 40, 40.
Yes.
Serial number 24 is what was pointed out to your lordship.
Yes.
Your lordship will find the description, material description. LT power cable, 3.5 so and so into 300 square millimeter, etc., etc. The unit is in meters and difference in quantity is 685 meters. Your lordship will find 2 very interesting things. Number 1, it does not mention that these are copper cables. These are copper cables. Because ultimately when the charge got framed, they tried to pin it on me, calling them copper cables. I'll come to that again. Copper.
LT power cable means it is of copper.
Need not necessarily be. Cables can be of various material. And second aspect is, if your lordship will kindly just have serial number 21, your lordship will find that there it is specifically mentioned as copper cable.
Flexible copper cable, there is multiple cables are here.
True, I was pointing out 2 things.
say that it is not of copper.
My lord will kindly just have a look at serial number 20 and 21.
Yeah,
Serial number 21. Wherever it is copper, they expressly mention it as copper.
this is not your defense.
I'm just pointing out the anomalies in the.
They are only defense. So this, that whatever the conclusion you have made, that is not admissible.
Yes.
The second defense which you have taken, that they have not been able to bring home the charges by producing cause and.
That is exactly my effort. I won't unnecessarily trouble your lordship. There are reasons why I'm pointing these facts out. As I proceed to the inquiry.
Copper cable or not copper cable, that is all together. Your basic defense is that it is not us who loaded that or allowed the loading of that whatever the 635 meters of cable. There it was not us, and there is no evidence that we were allowed them to lift.
But before that,
even this is your own, even this is not your case that this whatever the cable was found was part of that scrap. This is also not your case.
I am just trying to point out that they have not even been able to make out a charge against me. They when they frame the charges, now immediately I'll come to the charges now.
Yeah.
Now, if your lordship will, in this context, your lordship will come to the memorandum of charges that your lordship will find at page 110. And the specific charges are at page 112.
Yes.
Sri Diganta Haloy, charge number 1, while functioning as assistant manager commercial at NRL warehouse, Numaligarh, was looking after all activities related to disposal, including scrap, besides supervision of receipt and issue of materials in store and preservation of materials, etc. under his supervision. While posted and functioning as assistant manager commercial, NRL, Numaligarh, Diganta Haloy dealt with the disposal of CDU fire damage items for the e-auction ID number so-and-so. The fire damaged burnt cables were kept at the designated scrap yard located in north of road number so-and-so in between road number 5 and 7. But Diganta Haloy on 15/3/2014 in connivance with Sri Pankaj Boro unauthorizedly had allowed Messrs. Telex to load, your lordship will kindly note this one, 31.95 MT of cable, which was not part of the auction from other areas near the substation number 3, open yard number so-and-so. Now, the original material was never even weighed, so no one knows what that weight was. Here is a charge being framed, saying that this is the surplus material that I have allowed to be taken away. So if you don't have the basis, how did you arrive at this figure at all? That is the first fundamental defect in this. And the allegation is very serious, madam. In this, the allegation is that I, in connivance with Pankaj Boro, allowed 31.95 metric tons of cables, which are not part of the auction. Now, next, coming to the second one. During the said period, Diganta Haloy had raised the request for deputation of CISF official for witness on 14/3/2014, where he had mentioned the quantity as cut damaged cables, 60 MT approx, although the e-auction was held for so-and-so burnt cables and no weight was taken prior to the e-auction. Here they are themselves admitting that no weight was taken.
But so you yourself has mentioned 60 MT.
The reason is very simple one.
Okay. To
take a gate pass, I have to have some figure in that.
So that's why only your imaginary figure you have drawn that.
Yes. In the WS, we have taken that specifically. That without a figure mentioned, the CISF won't allow us to leave the premises. I have to give hypothetically some figure. Now,
then why only 60 MT? You should have mentioned 120 MT or 100 MT or 10 MT.
I could have, my lord. I could have, because from the naked eye, now they say that it is impossible to weigh because it will require a lot of cost will be involved.
Time, manpower and time, and therefore
they did not bother to weigh it. Now I am entrusted with the responsibility of disposing it off. I have to prepare a gate pass. And CISF won't allow me to leave the premises unless I mention some figure. So with my naked eye, this is our stated case, man. Now coming to number.
Yes.
Third chargement. Digonta Hollow allowed the lifting of 3 trucks of material from NRL premises by the buyer on 15/3/2014, which was not at all from the auction law. This is the charge. So I allowed, here they are now turning from the 31.95 MT. First charge is specific 31.95 MT. Now here they say that the entire 3 trucks was not at all from the auction law. So this charge itself, the third charge, directly contradicts charge number 1.
The charge number 1 is very specific, that this scrap material was lying at a place, and you allowed them, they allowed this Steel-X to get some other 30.95 meter of carrier from another place, which was not part of the scrap material. This is what the charge. Now, the third charge is also almost though it says 3 trucks, but 3 trucks material from the premises bar, which was not from the auction lot. These are almost connected.
No, but I have to, your lordship is aware of the law pertaining to disciplinary proceedings. One of the fundamental requirements is that when you frame the charges, in fact, that have, based on the law laid down by the Supreme Court, they have incorporated in the rules.
The court has also said that if you join the proceedings without raising any objection regarding the charges, then it means you are aware of the exact charge, what the exact charge is against you.
No, your lordship will, because at that stage, if I come before your lordship will send me back to face the proceeding. A delinquent employee gets the first.
The proceedings, maybe the court could have taken a view that the charges are not specific and therefore frame specific charges and then initiate proceedings against them.
Yeah, there are, my lord, a catena of judgments where the apex court as well as this honorable court has said that at the stage of charges, courts should not intervene.
But at the same time, there are also decisions. You get both sides of decision. That is there.
My lord, what I'm on is something else. What I'm on is, what am I defending? Am I defending 31.95 metric tons or am I defending all the 3 trucks?
Whatever the charges may be, you should, you have to disprove before this court that on account of this vague charges, you are prejudiced. Where is that case?
I'm coming.
You are prejudiced on account of these vague charges and therefore you are not able to defend yourself properly. This is what the law says. Once you have joined the investigation inquiry with open eyes, then it would be deemed that you are aware of what specific charge against you.
Your lordship is aware, my lord. In a disciplinary proceeding,
yeah,
though the principles of criminal jurisprudence have no application.
No application.
It is a employee can be convicted merely on preponderance of probability. Therefore, it is time and again it has been held that the procedural safeguards are of utmost importance, and that is where I am trying to indicate to your lordship that they are the ones who have conducted 2 rounds of preliminary inquiries. They have conducted investigations.
The problem is because before the learned single judge, you have not challenged this authority of the
authority. Even now, I'm not questioning.
The inquiry report, the inquiry officer, who conducted the inquiry, have not challenged. You have simply challenged it on the basis of
the merits of
evidence case. No evidence.
Exact.
Not even charges are vague or not vague. You have not mentioned anything. You simply said that they have not been able to prove the evidence, to bring the evidence on record to prove the charge. Charges as it is, you have no problem with the charges before the learned single judge.
But at the same time, although your lordship is absolutely right that we may not have very specifically urged that point, but On the face of it,
Specifically, the Leonard Single is recorded this finding, sir.
but still, your lordship is aware, my lord. Writ appeal is a appeal on principle. Your lordships can always go back into these materials.
These materials until unless the foundation is there.
Yeah, that is the foundation I am trying to lay. Now, my lord, coming to the fourth charge. Now, this fourth charge, your lordship will find that now it contradicts against 3 and 1. During disposal of the scrap material on 15/3/2014, Digonto Hollow in connivance with Pankaj Boro had allowed Messrs. T-Lex to take away 2 coils of copper cable of length 685 meters with a book value of 16.05 lakhs. First charge is 31.95 metric tons.
Yes.
Fourth charge is 2 coils of copper cable of 685 meters with a book value of 16.05 lakhs. The first thing, they ought to have clearly pointed out to me that this 31.95 metric tons is the 685 meters of cable. It is that very same thing. And it is this 685 meters of cable. Now, coming to the fifth charge, my lord. Digonto Hollow, in connivance with Pankaj Boro, had pre-planned to dispose scrap on 15/3/2014, which was an off day in NRL, to Messrs. T-Lex and issue non-auction materials as per his convenience by taking advantage of absence of other staff of the warehouse. So there are three, four components in this charge, my lord. First, it is pre-planned. Secondly, it was on an off day. And thirdly, I wanted to take advantage of absence of other staff. So these are the 3 components in this chart. Now,
You come to your explanation.
yes, now your lordship will, first, my lord, so far as this, just one thing I would like to point out from my written statement, which is at page 122. It's a very elaborate, each of these things that I have submitted, my lord, are into, it's a very long, detailed response that I submitted.
Yes, now come to this.
Coming to the relevant portion, my lord, it starts at,
How long it is?
it's very, very long. If your lordship wants me to read it, my lord, I can read it.
Read it. Please, for the clarity, read it.
My lord. With reference to your aforesaid memorandum enclosing therewith annexure 1, 2, and 3 respectively, asking me to specifically admit or deny the articles of charges, I, with due deference and profound submission, crave your indulgence to submit my written statement emphatically denying all the charges as mentioned in the articles of charges in annexure 1 and imputation of misconduct in annexure 2 leveled against me, and also for exonerating me from all the charges by dropping the departmental proceedings against me and not to impose any penalty. That I emphatically categorically deny all the alleged charges framed against me as mentioned in annexure 1, as well as the allegations of imputations of misconduct as mentioned in annexure 2 of your letter dated 10th June 2014. I also don't admit anything which is not borne out of record, cogent document, or contrary to and inconsistent with the records. It is stated that 5 numbers of charges have been brought against me by memorandum dated 10/6/2014 and has been directed to submit my written statement in defense within 15 days from the receipt of the said memorandum. As I was not supplied with documents relied upon, I made representations on 18/6/2014 and 26/2014. In response, while letter dated 27/6/2014 referred above, I was informed that aforesaid documents can neither be shown to me nor could be furnished at this stage, and was again directed to submit my written statement of defense within 15 days from the date of receipt of the said letter, but not later than so and so. However, I am submitting my written statement of defense denying all the charges leveled against me, since neither I was related from the beginning of the auction nor the lifting of the scrap auction materials on the incident day as has been done as per my direction or supervision, and therefore I be exonerated of the aforesaid charges. That while denying the statement of articles of charges as stated in so and so, I want to make the following submissions as well. That As regards the statement of article of charge number 1, while admitting that at the relevant time I was functioning as assistant manager commercial, I stoutly deny the rest of the statement under the charge in toto, and the authority is bound to prove such allegation charge. It is specifically denied that I was looking after all activities related to disposal, including scrap, besides supervision of receipt and issue of materials in store and preservation of materials, etc. The fact remains that the scrap material in question, that is lot number 2, e-auction ID number so-and-so, consists of electrical and instrumentation burnt cables, which is available in the e-auction document, including the e-auction summary. The fact also remains that while approving the e-auction, the competent authority approved to auction the materials in question in a lot and without a reserve price. Such fact is evident from the approval of such decision dated 30/12/2013. The scraps were auctioned as a lot and the materials shown in the e-auction were not specified. Such auction was meant for the scrap material arose due to fire at so-and-so. As there were insurance claims from NRL for such fire, and to ascertain the salvage of the damaged material out of such fire, the auction was carried out. Regarding the allegation that I, in connivance with Sri Pankaj Boro, had allowed Messrs. So-and-so to load 31.95 MT of cables, which was not part of the e-auction, are stoutly denied, and the management is put to the strict proof of the same. In this regard, the following facts are required to be considered. That when the auction materials were being physically loaded in 3 trucks by the auction purchaser, Messrs. Steelex, the trucks were placed at the locations where the auction items were placed. The loading of the auction materials were carried out by the laborers of the auction purchaser, as also with the aid of machinery. The entire loading time was approximately 4 hours from so-and-so to so-and-so. That a personnel of Central Industrial Security Force was physically present throughout the loading of the auction materials in the 3 trucks to ensure that non-auction materials are not loaded. The undersigned was present in the premises to ensure that the said loading was carried out under the strict vigil of the concerned CISF personnel. In my presence, no unsanctioned materials were loaded. If at all any non-auction articles are found loaded later on, the CISF personnel concerned is to be held accountable. That once these trucks were so loaded by the laborers of Messrs. Steelex, as also with the aid of the machineries, it is the duty of the concerned CISF personnel to sign on each of the gate pass corresponding to each of the 3 trucks. The reason for such signature of the concerned CISF personnel to be taken in each such gate pass is that it is the CISF personnel who is to be held accountable in case of any discrepancies while loading of auction materials. The CISF personnel is duty bound to inform the authorities concerned, that is CISF control room, along with warehouse officials, in case of detection of any discrepancy while loading of auction materials. The 3 numbers of vehicles were again taken on 23/2014 and released from the NRL premises after necessary verification. Therefore, such charge is liable to be dropped and the undersigned is required to be exonerated from such charge. That as regards the statement of article of charge number 2, it is stated herein.
Now, pause here. So in respect of this, you have denied that I have not allowed this 31 point MT and something. No objection regarding this, that 31 point MT is equal to 685 meters.
No, that is not. That is
There is nothing.
No.
You have also not explained when there is a specific charge that the scrap yard was lying at a particular place, but you are allowed to lift some cables from a other place, which is not the part of the scrap material. This was also part number 1 charge. You have not replied to that.
That has come out during the course of the proceeding through evidence. That I'll place, the evidence.
Here, at present, we are concerned with this explanation which you have offered. Yes.
That as regards the statement of article of charge number 2, it is stated herein that the writing of cut damaged cables 60 MT approx cannot be treated as acting prejudicial to the interests of the NRL, and same cannot be treated to be misconduct within the meaning of so-and-so, misconduct under etc. Rules for management of staff of NRL. In as much as such description has no malafide intention, nor the undersigned has allowed any scrap material to be lifted which are not auctioned. Further, the request for deputation of CISF official for witness is a format, and in the set format at row number 4 under the heading activity to witness it is specifically mentioned that loading of scrap cables so-and-so etc. 1 lot. Same description has also been given in the approval of e-auction dated so-and-so in the language the scrap materials consisting of ferrous and non-ferrous metal items including burnt cable. In fact, in the delivery order dated 13/3/2014, issued by ABC so-and-so. The quantity was consisting of electrical and instrumentation burnt cable. The fact also remains that while approving the e-auction, the competent authority approved to auction the material in question in a lot and without a reserve price. Such fact is evident from the approval of such decision dated so-and-so. The scraps were auctioned as a lot and the materials shown in the e-auction are not specified. Such auction was meant for the scrap material that arose due to fire at so-and-so, as there were insurance claims from NRL for such fire, and to ascertain the salvage of the damaged material out of such fire, the auction was carried out. Therefore, writing of loading of scrap cables, cut undamaged cables of CDU, VDU, fire, etc. in the request for 14/3/2014 has no nexus and or relation with the allegation charge made. Therefore, such charge is liable to be dropped and the undersigned is required to be exonerated, etc. Next, charge number 3. That the statement of article of charge number 3 is stoutly denied and the management is put to the strictest proof of the same. It is specifically stated herein that the vehicles were released without any offloading of materials and after due verification by the competent authority of NRL on 23/2014. Such fact clearly establishes that there is no basis at all for leveling the charge number 3. There is no material to show that the scraps lifted are not part of the auction material. Therefore, such charge is liable to be dropped and the undersigned is required to be exonerated. That the statement of article of charge number 4 is stoutly denied and the management is put to strict proof. It is specifically stated herein that the vehicles were released without any offloading of materials and after due verification by the competent authority of NRL on 23/2014. Such fact clearly establishes that there is no basis at all for leveling the charge number 4. There is no material to show that the 2 coils of copper cable of length so-and-so were lying in the open yard, nor there is any material to show that the said copper coils were allowed to be lifted. Further, on verification of the trucks on 23/2014 by the competent authority in NRL, no such copper coil was found. Therefore, such charge is liable to be dropped and the undersigned is required to be exonerated from such charge. That while replying to the statement of article of charge number 5, the allegation of connivance and pre-plan to issue non-auction materials taking advantage of absence of other staffs of the warehouse are stoutly denied and the management is put to strict proof. Further, at the time of lifting the materials, CISF witness was present and such witness was also allowed to be present by the competent authority on 15/3/2014. Therefore, allowing the lifting on 15/3/2014, which is said to be an off date, cannot be said to be misconduct in as much as even on off dates, NRL offices and different departments are being run. In absence of any material to show any malafide intention on the part of the undersigned cannot be charged with misconduct or acting in a manner prejudicial to the interest of the company. Therefore, such charge is liable to be dropped and the undersigned is required to be exonerated from such charge. That in view of the aforesaid facts and circumstances, it is apparent that the undersigned has not acted in any manner which is either prejudicial to the interest of NRL and or which tantamount to misconduct. The undersigned has not acted in any manner which can be said to be fraud, forgery, embezzlement, misappropriation, dishonesty in connection with the business or property of the company or property of another person within the premises of the company. The undersigned has also not breached any rules duly notified, nor the undersigned has violated any procedure laid down in connection with the company's business. That it is specifically stated here that the undersigned has not contravened rules so-and-so, etc. Now, imputations of misconduct are also dealt with. If your lordship so desires, I can read it. But one relevant thing that I wanted to mainly point out from this is page 130. So far as this so-called admission on my part, what I have said is at 130. The second paragraph in that page. The purported statement of the undersigned was not a voluntary statement in as much as such statement were typed, handwritten and printed by the authority of NRL and the undersigned put his signature.
Typed or handwritten?
There are, in some cases, they are handwritten. In some cases, they are the one before the departmental 3-member committee. Those were all handwritten. So what I read out from is the typed copies for the purposes of this court. In fact, if your lordship so desires, I can point that out. The undersigned put his signature under mental pressure and duress of the higher officials. No time was given to the undersigned to prepare such statement and obligor was allowed to write down his statement. He was forced to sign the alleged statement, which was typed, handwritten out by the officials, and the undersigned was not even given time to read out the statement after typing handwriting. Even after much request by the undersigned, by his communication dated so and so, the undersigned had not been furnished with a copy of such alleged statements. Such statement was neither read out nor the undersigned was given time to read the same. The undersigned has never stated before the authority the alleged facts as stated in paragraph 4 of
By
the
the
statement.
way, who this pressurize you to give this statement?
That those particulars are not there, but I have very expressly said that it was you who wrote it out. You made me sign on them. And when I asked for these statements subsequently, in fact, those two letters are also there, but all the materials that you have relied on, kindly give it to me so that I can prepare my defense. And they refused me.
In fact, the charge is not this that you have confessed this.
Yes, that is the point.
Charge, na?
There's no charge.
Okay, so where is the question of giving this statement?
Because they were trying to rely on this. So that is why I said that this is something I'm not admitting. And even if we take it on the face of it, what was it, assuming that the same can be considered to be an admission for the purpose of this inquiry? It was 1.5 metric tons to 2 metric tons. Now the allegation is 31.
Ultimately, the topic, this court, by this judicial review of this order only has to see whether there is some material available on record or not.
Yes.
That was the only question.
Fine.
That some material in support of the allegations they have produced or not.
Absolutely.
If
In that
there is
case,
no
my lord,
material, because we can't sit over as an appeal. That is settled law. We only have to see whether some material was there to bring up the charge or not.
Present.
If the material is there, matter ends there. If the material is not there, certainly judgment will up.
Now, my lord, on the basis of these facts, I'll straight away come now to the inquiry report and the evidence.
Yeah.
Before that, my lord, what is it that is now required to be proved against me? These are the facts. Long and short, my learned friend has taken your lordships through a lot of materials. What is it that was required to be established? There are two bundles found, two bundles of cables found, which were found to be suspicious.
Which as per them, not part of the auction property of what.
Absolutely. That is the
only
crux of the matter. Now they have to first, they have to connect it to the 685 meters. The 685 meters is the only material of usable material that is missing from their stores. Otherwise, if your lordship sees that chart, there is nothing else missing. The only
this
685
deficient. That much of the physical verification, they found that this much of cable is deficient from the report.
Absolutely. So the allegation of any misconduct of those going missing has to first, the first step has to be that it is those 685, the two bundles found are these 685. Now, in the verification, physical verification that was conducted, your lordship has seen one very fundamental discrepancy, which I pointed out, that copper is one aspect. The other aspect is, it is nowhere mentioned that it is in two bundles. They simply say that it is 685 meters that is missing. Now, first connection has to be with that. Second connection has to be that these 65 weigh 31.95 metric tons.
This is not a rotation. This whole, this is not a defense.
My lord, it may not be expressly taken because here is not a person who is defending himself with the assistance of a lawyer. A layman is defending himself. Now, my lord, without having established those connections to charge me with, what is it that they are charging me with? So now the charges as they stand, I defend. How do I defend? Your lordship will kindly first come to the findings in the inquiry report, page 142. I will deal with each of the charges. One. It starts at page 140. This is just a communication that inquiry report has been submitted. Then at page 141, the charges are reproduced and the findings start from page 142. The first charge. Statement of witness by G.K. Bora, Chief Manager Projects, taken on 19/1/2015, and Sri Hemanto Neo, Senior Manager Electrical Maintenance, taken on 9/1/2015, indicate the presence of designated scrapyard for so-and-so burnt cables and formation of a task force to deliver the CDU burnt cables to the designated scrapyard. However, your lordship will kindly note this one. These are two of the senior-most officers who are deposing. However, both of them did not confirm whether Sri Diganto Haloi was communicated about the designated scrapyard and task force meant for the purpose. Sri Diganto Haloi has admitted that the disposal was done from areas that is near the substation number 3 and open yard number 4. And as per his understanding, such locations are under the purview of the scrap disposal under inquiry. In this connection, Departmental Inquiry Report dated 2/4/2014 may be referred to. In his statement, your lordship, this is one of the witnesses. In his statement of witness of Nakul Bora, general workman, taken on 23/1/2015, he stated that scrap materials are not sealed in one location and various locations were utilized for the same. The matter of designated scrapyard for CDU, VDU, burnt cables and formation of a task force to deliver the CDU, VDU, burnt cables to the designated scrapyard was also discussed and recorded in the MOMs of the relevant CDU, VDU shutdown meetings in which the participants were from the technical functions. No documentary evidence was furnished during the proceedings specifically identifying the location and existence of a designated scrapyard and communicating the same to the Diganto. So the very foundation that was sought to be created, that it was only in one place, was totally refuted by the witness. And these are their officers. Now, next portion. Sri Diganto Haloi also stated that due to the pressure of the bidder, he jointly with Sri so-and-so decided to compensate the bidder by handing over old cramped twisted copper cable of around so-and-so for a long period of time. This, as claimed by him, was due to wrong information given by warehouse to the bidder, and the bidder was likely to forfeit the EMD amounting to so-and-so. The bidder demanded warehouse to refund their EMD or compensate their loss of rupees 1.75 lakhs. However, subsequently in his written statement of defense dated 12/7/2014, submitted to the Director Technical, Diganto Haloi denied this statement, saying this was out of mental pressure and duress of the higher officials. Statements of so-and-so, CISF Constable Pankaj Chaudhary, CISF Head Constable so-and-so reveals that Pankaj Boro and Diganto Haloi had allowed the materials to be loaded from areas near the substation number 3, open yard, and open yard number 4. Hence, the charge number, serial number so-and-so above against Diganto Haloi stands partially proved. Where is the scope for even partial proof, my lord, when their own officers are saying that these were scattered all over the place? So, therefore, my lord, this finding on charge number 1, even of partial proof, totally false true. Now, if your lordship will kindly see the statements given, my lord. Those are, in fact, some of the statements are part of the memo of appeal. If your lordship will take up the second volume at page 225. This is that Nukul Bora whose this evidence is on record. Page 225. It's a very long, elaborate cross-examination that takes place. And the question pertaining to location, your lordship will find at page 229. There are various 229, my lord, this is the specific question put to him. At the very top, your lordship will find the question.
Yeah.
At the very top of 229, whether there was only one location or more than that in the warehouse yard allotted to scrap materials, not sealed in one location, various locations were also utilized for the same. This is a very, very specific statement, and this person was also present on that day. On the date on which these materials were lifted, he himself was personally present. Now, in fact, my lord, these two senior officers who were that G.K. Bora and that Neo. Now, there are 2-3 questions. He is one of the senior most officers. Starts at page 230. In fact, one. How much instrumentation cable scrap was generated from incident of CDU video fire in terms of weight, length, etc.? Please provide details and records of handing over to the warehouse. Approximately 68,000 meters. So 180 numbers of cables consisting of single pair and multi-core, multi-pair of fire affected instrumentation, signal and control cables were replaced during the fire recovery jobs in CDO video. 3 types of cable scrap, unusable cables for instrumentation requirement were generated in the incident, namely total damage due to fire approximately 1/3 of the total length, multi-core cut pieces generated from fire affected cables, and multi-core cut pieces generated from new cables laid as replacement of the affected cable. Item number 2 and 3 are not usable from instrumentation point of view, as cut pieces were of shorter length than actual requirement at different plants. Joining of instrumentation cable cut pieces is not recommended to avoid losses of low-level instrumentation signal and disruption of process control signal. No records of these scrap unusable cables at instrumentation end were made, as these cables were dumped in designated location of scrap yard. Now, next question is very, very important. Who had brought the instrumentation cable scrap to the warehouse, and to whom were these materials handed over in the warehouse? Please state the specific location in the scrap yard where all these materials were dumped. Now he replies, majority of the damaged cables were brought to warehouse by a designated team formed by competent authority for debris clearance during the fire recovery job. A few unusable cable cut pieces were also transported to scrapyard by instrumentation contractor and dumped in the designated location marked by the warehouse for the purpose. No formal handing over process was intimated to executor from warehouse department. There were only a few unusable. Now, my lord, question number 6 is very important.
Do you have a copy of that tender document?
Tender, I don't think is on record.
Tender is not there. Page 100 is the approval for tender.
Hundred?
Is the approval for tender because it was in two lots, as your lordship will note, and which are shown by me also as by my learned friends. Total quantity, where is it? Lot one, lot two. Page 100. Ferrous and non-ferrous, so ferrous and non-ferrous. All the notings are on to proceed on this page.
Page.
100, 100. 1. In fact, it is mentioned there, the scrap materials consisting in ferrous and non-ferrous items, including burnt cables generated due to the above fire action are dumped at scrapyard. If your lordship sees, because my learned friend is making out the case that it was all over the place. Your lordship will see, has page 100. See the third paragraph in the first box. The scrap material consisting ferrous and non-ferrous material items, including burnt cables generated due to the above fire accident, are dumped at scrapyard and kept in a separate lot. And if your lordship
I just want to ascertain in the NIT whether you have mentioned it that this scrap material is dumped at so and so place.
No, it wouldn't be because I think it will because
Wouldn't be or it is there.
we'll have to verify that one. But if I may say, if your lordship will come to the third
This is
box,
approval order, sir. Ultimately, the main,
I follow what your lordship.
that is the NIT.
Yes.
Whether you.
that is the option.
325.
And my lord, yes. 319.
Three 85 is not. Hmm?
In the other
284. 284 में
the Pankaj Boro, it's on the
284.
Pankaj Boro, page number
319 and it's
319.
319. Starts 319.
Yes, sir.
It's only it's 319 because business rule is the rest. The specific it's, the site is not mentioned there, but also.
At 325 is the detail of disposal of revenue. 325. And it only says as is where it takes at 326.
325.
Which also reflects in the approval. We commit.
Lot 2 was the only one which was the auction. If your lordship sees, it says specifically only burnt cables. It does not say anything else. And lot 2 only says burnt cables. And and if your lordship sees page,
No, there was no opportunity for the bidders to go and check, look into the material that it was dumped there. So go and see, and then only they can they are able to this off the price.
inspection of goods. I follow what you're doing. The material as per say item 2, my learned friend says, page 326, item 2.
326, item 2.
Please note. The prospective bidders may inspect the material offered for e-auction sale within stipulated period of the site where the material is located. The bidders shall satisfy themselves with the quality, quantity, measurements, etc. of the material which they intend to purchase. No complaints shall be sufficient. As is well. So, well, The lot one, they did not take, my lord, because they cancelled that, if your lordship will recall. I think it's at page 433 in the first petition. Now I start remembering. Where is the note here? Page 100 over there. Exactly what I'm saying. It is there in page 41. Because people who went to the land, they went to the west.
Yes.
Just to clarify on the scrapyard and this warehouse part, because the note says they are lying in the scrapyard, no note for approval. They said as is where is basis. Now, if a lordship recalls, in that statement which they made before the first inquiry, they said they took them to the warehouse. After that, physical verification is done. Then, after physical verification, when he is examined again, this is what he says, and I'm just reading out for your lordships, page 41. The question and answer. In your earlier statement dated 3rd of April, you have stated that after lunch around 2 p.m., the third truck was taken inside the warehouse to open yard 01 and 02. Load of cables was loaded with the help of crane. The materials to be loaded were identified by me and senior manager materials. On inquiry of the same to senior manager materials, he informed that although you had discussed regarding compensating the buyer by giving a cramped twisted cable lying in 0101, he had stated that the same was not possible. Please give your views. On that day, that is 15th of March 24, he gives a further explanation. After loading the 2 trucks this is the answer, at SS3, lunch break was taken by all, including CISF customer and loading party. During lunch break, the customer approached us for loading of the cables which were meant for compensating the EMD myself. Both myself and senior manager along with the customer went to the site and both of us identified the cramped twisted cable lying at 0101 to lift the same after lunch break. So he says in the answer to the first question, he had already said he's gone to the warehouse. So the NIT says the note for approval says scrapyard. They are saying it's different location. They themselves say they went to the warehouse.
Yes.
In fact, the query that has fallen from your lordship, not only is it reflected in the NIT, it is also reflected in the approval itself, that it is on the way, it is described as 2 lots and as is various basis. This is at page 100.
Here it says the scrap material consists of the and furniture item including generated due to above fire accident are dumped at scrap yard and kept in separate lot.
But Later on, they also say as is, where is basis. And during the course of the,
As in where is basis means where it
Yeah.
is
I'll-
lying on the basis of that.
that is what now it emerges, not from my, this thing, my lord. If your lordship will kindly come back to page 231.
Yeah.
Now, this is, I was reading out the chief managers. This is the chief manager instrumentation, one of the highest officers, my lord, in that department. Now, I had read out question number 1 and 2. If your lordship will kindly come to question number 6 at page 231.
231, yes.
During visit to the scrapyard on 26/3/2014, 2-3 heaps of burnt scrap cables were seen. Are these the CDU video burnt cables that were handed over to the warehouse after the fire incident? His answer: majority of the cable cut piece and burnt damaged cables seems to be generated from the fire incident. However, after a period of 9 months, it is difficult to ascertain the original source of cables present in the heaps. Then question number 7. On 23/2014, 3 truckloads of scrap seized by the police were unloaded for verification in the refinery. Who from your department was present during the verification and what type of materials were observed in the trucks? Details may be given. Mr. Sanjeev Gogoi, manager instrumentation, and Mr. So-and-so Bora, deputy manager instrumentation, were present from the instrumentation. As reported by them, during the visual inspection, most of the instrument cable seems to be either physically damaged or loose cut pieces. However, actual length and physical condition could not be ascertained as measurement and testing was not carried out by police investigation team on the verification day. Comment on the electrical cables may be obtained from electrical department. Now, this is the chief manager who makes these statements. Then is the senior manager, which your lordship will find at page 233. This is again another senior officer from the concerned department. Question number 1.
Yeah.
How much electrical cable scrap was generated from incident of CDU video fire in terms of weight and length? Please provide details and records of handing over to the warehouse. During recovery of CDU video plant, approximately 37 kilometers of healthy new cables were used to replace the fire affected electrical power and control cables. Damaged, unusable electrical cables generated in the incident were due to total damage in the fire, multiple cut pieces generated from fire affected cables and cut pieces of new cables during the replacement job. No records of these damaged, unusable cables at electrical end were made as these cables were dumped in the designated location of scrapyard. Scrapyard is located in north of so-and-so in between road number 5 and 7. Question 2.
Here now he has clarified.
Now, going further, man, who had brought
is located in north also and so. So he is
scrap yard is located there. He is not saying that these materials were all in one lot there.
dumped in designated location of scrap yard. Scrap yard is located at so and so.
Well,
That is
No.
he has mentioned.
but this,
Warehouse and scrap yard, two different.
well, in fact, going further, Malu, question number 2. Who had brought the electrical cable scrap to the warehouse and to whom were these materials handed over in warehouse? Please state the specific location in the scrapyard where all these materials were dumped. Now they are simultaneously using the word warehouse and the scrapyard. Majority of the damaged cables were brought to warehouse by a designated team formed by competent authority for debris clearance during the fire recovery job. A few fire damaged unusable cable pieces were also dumped by our department at the same scrapyard. So only a few were dumped at the scrapyard. The designated location marked by the warehouse for the purpose. No formal handing over process was intimated to executor from the warehouse department. Now here he says only a few were kept in the scrapyard. And question number 6. During visit to the scrapyard on 25/3/2014, 2-3 heaps of burnt scrap cables were seen. Are these the CDU video burnt cables that were handed over to the warehouse after the fire incident? Majority of the cable cut piece and burned damaged cable seems to be generated from the fire incident. However, after a period of 9 months, it is difficult to ascertain the original source of the cables present in the heat. So he absolutely reiterates what his senior has said, and this is a senior manager.
Come to question number 4 also.
My lord. Was any burnt scrap electrical cable dumped near substation 3 and cable yard near raw water treatment plant? At the time of visit by insurance team, to the best of our knowledge, the fire damaged unusable cables of so-and-so were found dumped only in the above said designated location of scrap yard number so-and-so. But in the previous question,
Yes.
however, in question number 2, he replies saying that only a few were brought to the scrapyard. Now, the question number 7 at 235. On 23-24, on 23-2014, 3 truckloads of scrap seized by police were unloaded for verification in the refinery. Who from your department was present during the verification and what type of materials were observed in the trucks? Mr. Rajiv Sharma, manager, was present from the electrical department. As reported by him during the visual inspection, most of the electrical cables seem to be either physically damaged or loose cut pieces. In addition to above, 2 rolls of larger dia of cables were also observed in one truck. Actual length, healthiness, and usability of the electrical cables could not be ascertained as measurement and testing were not carried out by police investigation team on the verification day. Comments on the instrumentation cables may be obtained from instrumentation department.
Yes.
Now the CISF personnel is at page 236. The CISF person who was present on that day. 239 not asking.
Page 39.
पूरा पढ़ना पड़ेगा.
This one. Mal, no.
It is very unique.
Mal. It starts at 236. Question from presenting officer to Pankaj Chaudhary. Please let us know your name and your CISF number. My name is so-and-so and CISF number so-and-so. Since when have you been with CISF NRL unit? July 2011. On 15th March 2014, whether you were on duty. I was on general shift duty on 15th March so-and-so at main gate in trolley mirror. How did you come to know about the scrap loading from refinery campus on that day? I was called from CISF control room at around 9:30 a.m. What kind of duty or responsibility was assigned to you related to scrap loading on 15/3/2014? I was given a witness requisition slip by Sub-Inspector Sri so-and-so, and I was advised to be present as loading witness to report at the weighbridge. At what time you have arrived at weighbridge? At around 9:35 a.m., I was present at refinery weighbridge. Whom did you meet there at weighbridge? I met Sri Diganta Haloy, whom I did not know earlier and got introduced to him there. Whether you have read witness slip before proceeding to report at weighbridge? Yes, I read the witness slip. What were you advised by Diganta Haloy? What did you see at the weighbridge? There were 3 empty trucks near the weighbridge. It was told that the weight of the empty trucks will be taken. Accordingly, I have inspected the trucks and the weight of the trucks were taken. What did you do after the weight of the trucks taken? I was advised to proceed to the loading area and I proceeded along with the trucks. At what time loading was started? At around 10 a.m. loading was started. Which location loading started? Sri Diganta Haloy asked me to go near substation number 3, where the loading was started. 2 trucks were taken to substation 3 area, and 1 truck was advised to wait in front of the warehouse gate near CISF cabin. As advised, I went to substation 3 along with the 2 trucks, and Sri Diganta Haloy also proceeded to substation number 3. I also saw 1 more NRL personnel near the weighbridge, but I did not know the person. When we came to substation number 3, he did not come along with us. However, he came to substation number 3 at around 10:30 a.m. On asking Sri Haloy, he told me that he was also NRL officer and senior to him. When you have arrived near substation number 3 for loading, whether there was any other person reported for assisting in loading or any other crane, etc. also there. I have noticed 3-4 numbers labor. I have asked Diganto Hale about which cables were to be loaded, and he has shown me some old junk bunch of cables scattered on the ground in that place. Initially, small crane reported at the loading spot. After arrival of the trucks, loading was tried with that small crane. However, loading was not successful. Then a big crane arrived there. Then the loading was done with the help of big crane assisted by 3-4 laborers. Whether both the trucks were loaded near substation 3 and approximately what time was taken for loading near substation 3. Both the trucks were fully loaded there. I can't remember exactly how much time it took to load the 2 trucks. After completion of the loading, trucks were asked to move to near warehouse gate. Accordingly, I instructed the trucks and came along with them. The trucks were waiting near the warehouse. After that, Diganto Hale left for lunch. I was waiting there. What about the third truck? After lunch at around 1:45 p.m., Diganto Hale came back. I was taken by him to inside the warehouse gate and shown me cables lying on the ground. It was the open place near the warehouse main gate where the cables were lying. The big crane which was waiting outside the gate went inside the gate. Then the truck went inside the gate to that place for loading. 3-4 laborers were present at that spot and they assisted loading. The cables were loaded by the crane. What kind of cables were loaded from inside the warehouse? Okay. Only cables were loaded. These cables were also lying like the earlier cables loaded. I have asked Diganto Hale twice whether these are the cables for loading. Then he inspected and confirmed that these are the cables to be loaded. 2 bunches of cables were loaded from that place. Then he told that more cables will be loaded from some other place and asked me to move to other place. Then I was taken to the open yard near watchtower number 2. The third truck, which was half loaded, was taken to that place. Then more cables were loaded at that place. The crane also went to that place and loaded in the same truck. After loading was done, I was advised by Diganto Hale to go to the refinery weighbridge. After that, I took all the 3 trucks to the weighbridge. It was around 3:30 to 4 p.m. We arrived at weighbridge. After around 10-15 minutes, Diganto Hale came to the weighbridge. Then the loaded trucks were weighed. Gate passes for the 3 trucks were given to me. Then I proceeded to the material gate, taking the 3 trucks. I have signed the gate passes after completion of the weighing. I have reported information about loading of trucks to ASI M.N. Joshi at material gate and also handed over the copy of gate passes. They have checked the vehicles and allowed to go out. After that, I came back to company office and deposited the witness requisition slip. Whether you knew about which material to be loaded from which place and what quantity when you have reported at the warehouse for witnessing the loading. I did not know about the locations where from the materials would be loaded. As per my knowledge, damaged cables were to be loaded and no other items were to be loaded. I did not know about the exact quantity to be loaded. Whether there was anybody present from the party who was buying the materials, I did not know. Whether Diganto Hale was present during the entire period of loading of cables at different places as you mentioned above. Yes, he was present. Whether any material was loaded in any place other than the 3 places mentioned above, particularly at scrapyard north of road number 6. No, not loaded. Did you cross-check the vehicle numbers mentioned in the gate passes against the trucks where materials were loaded? Yes, I verified. This now cross-examination by one Mintu Handig on behalf of Pankaj Boro. When you have joined in CSF, September 2006, what is your first place of posting? Oil India Limited, Duliajan. What is normal interval of transfer in CISF 2 to 4 years? On 15/3/2014, whether any document submitted to CISF person posted at warehouse main gate while entering the truck for loading or when coming back with loaded truck at the time of exit. No document submitted. However, Diganto Hale has taken the witness requisition slip from me and shown it to head constable so-and-so. Then he allowed truck to go inside the loading. For loading. Then I took the slip back. No document was verified while coming after loading. Rajut Bora was also present during the loading time. Now, cross-examination by Kumud Saikia on behalf of Diganto Hale. You are Constable Pankaj Chaudhary bearing CISF number, etc., working in NRL unit. Whether is it correct? Yes. On 15/3/2014, whether you were allotted the duty at warehouse area for witnesses of loading of 3 numbers of trucks of scrap materials of CDU, video, damaged cable, whether it was correct. I was on duty that day only for witness of loading of 3 trucks. Whether you have received any witness requisition slip on so and so. Yes, I have received from CISF control room. What were written in witness requisition slip for witnessing, as you have replied against query number 8 of PO, that you read the witness requisition slip? Yes, to be witness for damaged cable of CDU video file. Whether you have strictly followed that witness requisition slip at the time of loading of 3 numbers of trucks. Yes, I have followed the same strictly. Now, this question is very important. You have replied against the query number 16 of PO that 2 bunches of cable were loaded in truck number 3 on that day. Whether these cables were as per your witness requisition slip, I could not verify. On visual observation, it looked to be old damaged cables. They did not appear to be new cables.
This CI, personally, you are asking such type of this technical questions.
But the technical people, he is corroborating the technical people. Man.
They simply corroborated that Diganta, who is this Diganta Olai, he directed him to the substation number 3, and from there some was lifted, some cable was lifted. This is what material is this, and you have not cross-examined him on this point at all. Not a single question. He has verified that not from 6 and 7 and from substation number 3. Yes, Diganta Olai took me there and he said, this is the cable, this is to be lifted, and I got it lifted. This is what evidence.
What I was trying to indicate from these evidences is that here are 3 senior officers, 2 senior officers,
Sir,
and another employee.
Just what is the normal? The evidence, prosecution evidence is so far that the auction material was placed
In one place.
At one place, that is in between road number 5 and 6 and something, that scrapyard. This person has allowed lifting of cable from another location, which is not the where the auction material was not stored or not placed. And that is substation number 3. These person, all those persons, the other witnesses, though they have not said anything about this substation number 3, but from those statements it can be gathered that they are saying the scrap material was placed at so and so 5 and 6 number station scrapyard in between road number 5 and 6. Now this person, CAFS person, he has said, yes, Diganta Olai said, substation number 3 say, I have to lift, and from where in his presence the cables were lifted. This is what the plain and simple evidence.
What was, Malad, that is why we have to fall back on the charge. The charge is apparently, they have connected it to usable new cables going missing from their warehouse of 685 meters. That is they expressly, we can connect it because that is the 685 meters that they mention in charge number 3. Charge number 3, if your lordship.
Mr. Chaudhary, the sum and substance of the application, what type of cable, what type of material is not the it is not the say that the relevant thing. The relevant thing is the charge against you that you have allowed lifting of some material which was not part of the auctioned property, and that they have to bring home the charges. For that, they have produced the evidence that this auction property was lying at a particular place between road number 5 and 6. You have allowed to lift some cables, whether it was used, new, or whatever it may be, unused or cutting or whatever it may be, from a place which was not designated for keeping the auction property. That is what the charge is.
Now, if we take that as the only charge against me,
that's what the sum and substance of the charge is this. Otherwise, pre-plan and everything, that is absolutely nothing. There is no evidence of that. Yeah, you pre-planned with them or whatever it may be, that is not there.
Now, if that is the only charge, that I have lifted materials placed going by the
Auction, which was not auction.
which was not option. And going by the example that has fallen from your lordship, place A is designated.
Yeah.
It is at place A where all the fire damaged materials are kept.
Auctioned material. You can caption it as an auction material.
Auction material.
Fire or new or old, that is absolute auction material.
So what I was trying to indicate from these evidences is, and that is what the inquiry officer also more or less records, that it is not correct to say that these were at one place.
That's absolutely.
So now, if they were not at one place and if they were
And if
scattered,
it is listed from some other place also, then certainly it is a part of that auction property.
yes. Now, if that be so, they will have to haul me up to return home of finding of guilt, and on the nature of the guilt has to be of such nature that it should invite a major penalty. So that is my lord line of argument. Now, my lord, coming to charge number 3, if your lordship will kindly first have charge number 3 at page 112.
Sorry to say, we are interrupting you. The sum and substance of all the charges is only this. That you have allowed a person to lift the property which was not specifically auctioned.
Absolutely.
That is what the sum and substance of all the 5 charges.
Grateful. If that be so, now if we, in that context, if we have a look at the findings in the inquiry report once again, if your lordship will kindly come back to the inquiry report. Page 141. Now, my lord, the findings start from 142.
Yes.
Now, may I trouble your lordship once again from the very first charge?
Yeah, yeah.
What is it that led to the conclusions? Statement of witness G.K. Bora, taken on 19/1/2015, and Hemanto Nayo, senior manager, taken on 9/1/2015, indicate the presence of designated scrapyard for so-and-so cables and formation of a task force to deliver the so-and-so burnt cables to the designated scrapyard. However, both of them did not confirm whether Diganto Haloi was communicated about the designated scrapyard and the task force meant for the purpose. Sri Diganto Haloi has admitted that disposal was done from areas that is near the substation number 3 and open yard 4, and as per his understanding, such locations are under the purview of the scrap disposal under inquiry. In this connection, departmental inquiry report dated so-and-so may be referred to. In his statement, witness Sri Nakul Bora, general workman, taken on 23/1/2015, he stated that the scrap materials are not sealed in one location and various locations were utilized for the same. The matter of designated scrapyard for CDU, VDU, burnt cables and formation of a task force to deliver the CDU, VDU, burnt cables to the designated scrapyard was also discussed and recorded in the MOMs of the relevant CDU, VDU shutdown meetings in which the participants were from the technical functions. No documentary evidence was furnished during the proceedings specifically identifying the location and existence of a designated scrapyard and communicating the same to Sri Diganto. The finding is that there is no designated scrap. And based on that, now they record his so-called admission and also the fact that the admission is retracted in the next paragraph. And thereafter, statements of Hydra operators, helpers, CISF Constable Pankaj Chaudhary, Head Constable so-and-so reveals that Pankaj Bora and Diganto Haloi had allowed the materials to be loaded from areas near so-and-so open yard, so-and-so. Hence, the charge number 1 above against Diganto Haloi stands partially proved. Now, he records a finding that there is no designated scrapyard. There is no designated places where the auction. So how could he have even said that it is partially proved? That is my case before. So therefore, so far as the first charge is concerned, it's a clear case of no evidence. Now the second charge. In the summary of defendant submitted on so-and-so, Digonta Hollow admitted that as there is problem with creation of gate pass as lot for 3 vehicles, therefore a rough estimate was considered. And accordingly, vehicles were weighed and SAP transactions were carried out for proportion and quantities. This all was done as per direction and with due intimation of HOD. This was evident from the fact that gate passes and invoices were authorized by HOD, so-and-so, so-and-so. Hence, the charge number 2 above Digonta Hollow stands proved. What is one iota of material in respect of this charge that has been recorded against me? Not even an iota of a finding that is recorded against me. And he says that it is proved. Now, third, statement of witness. G.K. Bora, chief manager taken on so-and-so, so-and-so. This is more or less a replication of what he records. Total replication. And again, he says partially true. Where is
application come
next one? 4. Digonta Hollow stated that due to the pressure of the bidder, he jointly with senior manager materials decided to compensate the bidder by handing over old cramped twisted copper cable of so-and-so, so-and-so. Again, he basically records, and thereafter he records that I have retracted this. So he is not even relying on this. Statements of so-and-so, again repetition of so-and-so taken. In the physical verification by stores at open yard on 9/4/2014, report submitted by Probir Talukdar on 11/4/2014 against occurrence of the incident on 15/3/2014, it was indicated that there was storage of 685 meters copper cable with tag number so-and-so. Now, out of the blue, they use the word copper here. Statement of witness of G.K. Bora, so-and-so, again repetition, by Probir Talukdar, CM commercial taken on 7/1/2015 and report from so-and-so, dated so-and-so, do not confirm that 2 coils of copper cable of length so-and-so meters with a book value of so-and-so from the open yard were a part of the scrap disposed of on 15/3/2014. They do not confirm.
I do not confirm they were not part of that.
No, if your lordship kindly read the whole thing again.
Yes.
In my humble understanding, my lord, it is the other way around.
No.
Statement of witness G.K. Bora, chief manager projects taken on 19/1/2015 by Hemanto Neog, senior manager commercial taken on so-and-so, by Sri Probir Kumar Talukdar, CM commercial taken on so-and-so, and report from SDA so-and-so, dated so-and-so, do not confirm that 2 coils of copper cable of length so-and-so with a book value of 16.05 lakhs from the open yard were part of the scrap disposed of on 15/3. So this was not.
They will not confirm that this
685
part of the scrap yard.
Yes. No, do not confirm that it was part that was disposed of on 15/3. The word used is disposed of. They are saying that there is nothing to show that this 685 was disposed of on 15/3/2014. In essence, what he is trying to say is these materials do not show that this 685 is what was disposed of on so-and-so. Because that book value also I'll show, man. They have to first demonstrate that it is a new cable. Only then it has a book value. Otherwise, it will not have a book value.
Yes.
From their own documents that I'll come a little later.
Okay.
Presenting officer in his summary of reference of evidence of imputation of misconduct in support of articles of charge framed against Digonta Hollow, assistant manager, submitted by him over email on 22/2/2015, along with the exhibits mentioned therein and taken on record during the proceedings held on 25/2/2015, referred to photograph of cables taken on the truck subsequently, while the truck was under police custody. However, presenting officer did not disclose availability of such photograph during the mutually agreed period of disclosure of documents by presenting officer and defendants, nor did he furnish such photographs before me. Hence, charge number 4 against Digonta Hollow stands partially true. What is there? Anything against me? Rather, these officers are saying that these 685 meters of book value 16.05 lakh.
Yes.
Now, next one. Diganto Halle cited certain reasons of urgency for proceeding with disposal of scrap on 15/3/2014, which was an off day in contravention of e-auction terms and condition without any approval. In his defense, he did not furnish any document containing approval for deviating from terms and conditions of e-auction, nor did he furnish any reason for not seeking such document of approval from his superior before proceeding for disposal on an off day. In this connection, statement of witness of so-and-so Chakravarti taken on 19/1/2015 can be referred to, wherein Aruni Prasad Chakravarti stated that deviations to conditions laid down in the business rules, terms and conditions for disposal of scrap materials has to be routed to the committee, which originally approved the business rules, terms and so-and-so.
That is ultimate, nothing.
Now, so anything that we do from nowadays from your lordship's pass an order and sign it on Saturday or Sunday will become invalid going by this.
That is not right. That connivance charge is not pre-planned and nothing.
Now, my lord, your
So
lordship
now,
has seen.
all this, you mean to say that there is no evidence and
Absolutely.
they are relying on this as evidence.
And your lordship will see.
No point.
Now, my lord, just one more factual aspect, your lordship, I must point out to your lordship, my lord.
What?
This, when the matter is placed before the disciplinary authority, he says that on charge number 4, conduct a further inquiry. Now, if your lordship peruses that further inquiry,
Ignore that. Ignore that.
my lord.
Ignore that photograph and all. Ignore that.
Now,
Though strictly speaking, and you are also admitting that the Evidence Act is not strictly applicable, then this 65A and 65B and all.
Otherwise, my lord, the reason is this one. Strictly Evidence Act may not be applied. But otherwise, your lordship has very recently, we have witnessed, my lord, in a slightly lighter way, how Pakistan is merrily peddling all fake videos. Fake videos will be produced if no one certifies it, and it will. I'll be
the other party, even though the strict application is not there, but this photograph and videos, the person who
took the photo.
At least he should have come and said, yes,
Yeah, I
this is
took
the photo.
exactly. Exactly. Otherwise, my lord,
These photos and all, maybe strict proof of that evidence is not required, the certificate is not required, but at least that person should have come and said, okay, I have recorded that.
Absolutely. And
non-scrap material actually they are
Yes.
now, my lord, just one thing to indicate to your lordship, to quote us, book well page on
Finish it off, sir.
263 now.
Mr. Chaudhary, almost we have heard you whole day. Now finish it off.
Yeah.
Any law point?
Whole day he has taken, my lord. I have taken only 1 hour.
Yes, taken. Please, from last 2 to this 4, you are arguing. What else?
Relevant page to that. Annexure. If your lordship will just have 243 and 244, just for a moment, to have a book value. I just wanted to, this is something we had brought out before the Lord and Single Judge, 343.
Yeah.
So something will have a book value only if it is not scrap. If it is scrap, it is always shown as value is shown as 0.00. So to say that those 31.95 metric tons of cables have book value, it was a requirement on their part to bring it on record by way of any form of evidence.
Yes.
343 and 344 will indicate that it is only when these are new cables. Now coming to the, my lord, entire thrust of the argument on the part of the appellants has been total reliance on my purported confession made before two
Fact-finding inquiry.
preliminary inquiries. What is the value of a preliminary inquiry has been dealt with by the apex court very, very recently. In fact, my lord, judgment to court.
24 SCC on.
We have given this judgment.
Kendra Singh.
In fact, my lord,
Citation to call.
I feel proud to say that my lord, Honorable Mr. Justice Sandeep Mehta has passed this judgment, relying on several judgments. And I am relying on three paragraphs.
Yes.
If your lordship will first come to para 14. Because Honorable Single Judge has also relied on Roop Singh Negi. I am placing this para 14 first.
Yes.
In the case of Roop Singh Negi, this court held that mere production of documents is not enough. Contents of documentary evidence have to be proved by examining witnesses. Relevant extract thereof reads as follows. This is so far as this, what is the requirement of proving the documents. I am not troubling with the quoted portion para 14. Your lordship will come to 15. We have noticed herein before that the only basic evidence whereupon reliance has been placed by the inquiry officer was the purported confession made by the appellant before the police. According to the appellant, he was forced to sign on the said confession as he was tortured in the police station. The appellant being an employee of the bank, the said confession should have been proved. Some evidence should have been brought on record to show that he had indulged in stealing the bank draft book. Admittedly, there was no direct evidence, even there was no indirect evidence. The tenor of the report demonstrates that the inquiry officer had made up his mind to find him guilty, as otherwise he would not have proceeded on the basis of that the offense was committed in such a manner that no evidence was left. Now, my lord, your lordship may skip this portion and come to para 16. This deals with this. I just wanted to point out from para 14 what is the situation with regard to admissions. Now, para 16 deals with preliminary. In the case of Nirmala Jhala, this court held that evidence recorded in a preliminary inquiry cannot be used for a regular inquiry, as the delinquent is not associated with it and the opportunity to cross-examine persons examined in preliminary inquiry is not given. Relevant extract thereof reads as under. A constitution bench of this court in Amalendu Ghosh versus so-and-so.
So that is the relevant court.
Well,
Debate.
so therefore, all the cases on preliminary inquiry have been relied on in that paragraph itself.
Yes.
Now, this is so far as the heavy reliance placed on the preliminary. Now, the judgments that have been placed on my so-called admission, firstly, there is no admission to what is ultimately charged. I had, assuming it can be accepted, are admissions with regard to some 1.52 tons. Each of these judgments, your lordship will find, those were admissions made during the course of the inquiry, not at the time of some preliminary. So I'm not troubling your lordship with all those. I'm going as fast as possible. On the electronic evidence also, I'm not troubling your lordship. Now, my learned friend today had placed the judgment on the scope of 226. In fact, I will rely on that same very judgment. I'm rather grateful to my learned friend for placing this 75 to court. 75 to basic.
22 paragraph. Paragraph 22. I read that.
Page 26. The compilation.
Yes.
I unfortunately don't have a copy of the compilation, but
my lady friend have.
Yeah, your lordship will, this is 75 volume 2 SSC 557.
Chitra Venkata.
Mal. And your lordship will kindly come to the same paragraph 21 relied on by my learned friend.
Yes.
The scope of Article 226 in dealing with departmental inquiries has come up before this court. Two propositions were laid down by this court in State of AP versus Sri Rama Rao. First, there is no warrant for the view that in considering whether a public officer is guilty of misconduct charged against him, the rule followed in criminal trials that an offense is not established unless proved by evidence beyond reasonable doubt to the satisfaction of the court must be applied. If that rule be not applied by a domestic tribunal of inquiry, the High Court in a petition under 226 of the Constitution is not competent to declare the order of the authorities holding a departmental inquiry invalid. The High Court is not a court of appeal under Article 226 over the decision of the authorities holding a departmental inquiry against a public servant. The court is concerned to determine whether the inquiry is held by an authority competent in that behalf and according to the procedure prescribed in that behalf. And this portion I'm relying on. Whether the rules of natural justice are not violated. Second, where there is some evidence, so there has to be some evidence, which the authority entrusted with the duty to hold the inquiry has accepted, and which evidence may reasonably support the conclusion that the delinquent officer is guilty of the charge. I'm relying on this point. And then any considerations extraneous are taken towards the later part of the paragraph, or irrelevant considerations come into play even then. So in my respectful submission, on the basis of the facts, the law on which there cannot be any quarrel. Here is a case, my lord, which is entirely all findings have been returned on each of the charges without any evidence to implicate me, sir, directly. So therefore, my lord, in my respectful submission, the learned
Yes,
thing
ma'am.
Lordship, I appear for the senior sales.
The senior officer.
Senior officer, the senior sales. Few things at the outset. Here. Lordship will hear me.
Yeah.
Lordship, few things without going into merits of the charges. Who am I and what is my role? Because that's the important point.
You are the senior person?
Yes, I'm a senior person by way of an office order. Office order, office order. The hierarchy is, there is Nakul Bora, you've heard. Nakul Bora is responsible for disposals. He reports to Diganta Haloy. And I am the senior most who everybody reports to. So I am right on top. I am not responsible for checking.
Directly
involved in this.
Yes.
Lordship, this is the office order. You'll find mention of it in page 150 of our paper book.
Fine.
We referred to this to establish that there is an order and this is issued by me. So it is the chain of command under me. So Diganta Haloy reports to me. I am not responsible for looking after what is dispatched, what is not dispatched. That's number one. Number two, the decision to allot, decision to auction in lots was by a 3-member committee, not just me. So nobody else is indicted, only me. It was decided because there was, when it was done, there was no question of weighing. It was decided that if we start weighing now, it will be enormous time and enormous consent. So therefore, the decision to go ahead for lot system was by a committee, and the committee is as prescribed by the delegation of authorities, clause 23.
You are one of the member of that committee.
Yes, and it was, that is. 3 is, Your Lordship, may I just give you my submissions? The pages are there, so I don't have to trouble you with going over.
You just make a.
Yes.
Because now the facts are very clear.
Yes.
Nothing.
Third is I was not present there. How do I say that, Vidya? How do I
One
say
of the
that?
witnesses said you were present there.
Yes.
Simply one officer is saying, he asked, then he said, he is my.
Lordship, now if you notice that CIFF, which was read out in detail, my punch card, when I got in, is 11:29. He mentions 10:30. He saw somebody one at 10:30. So I could not have been the person. Plus, when the 2 coils are found in the 3rd truck, not the first 2 trucks. So if anybody came, it was at 10:30. It couldn't have been me because I entered the office at 11:29 according to punch record of the appellant authorities. That's number one. Number two, Diganta Haloy himself says that at the time of, at page 279, his statement is at the time of actual loading, I was not there. CISF, Pankaj Chaudhary, I was there in the room. He said, I can identify the person who else was there. He doesn't identify me. So I am not this thing. I was not present.
Look, you were implicated only on the basis of the, this confessional statement of the.
Of which I don't deny. Lordship, if I had to lie, I could have lied and said he never came to me. I don't say I don't. I said he came to me, yes, but I said absolutely not. You can't do that. That is what it is. Now, what is the evidence on the basis of which the main charge? I'm not on the other ancillary charge. There is one charge of insubordination that I went ahead with lot system, auctioned in lot system when I should not have. That is first. Second is an off day. There is evidence of.
These are the same or charges?
No, the charges are different. There are six different charges. Yeah. The common charges are 4, 5, 6. 4 is it's not from the auction lot, and I did not effectively supervise. So I did not effectively see that everything from the auction lot was not taken out. 2 is what was this. There was no designated. It was not taken out from the designated area. The same thing. And the final thing is theft. Theft is the main thing. Theft is what that is missing. That is 6.
Missing, unauthorized.
Unauthorized, yeah. But effectively, it is theft, Your Lordship, because they've imposed a.
Exactly theft. In fact, you have allowed.
Missing.
The charges that you are in connivance with the.
Yes.
Lift the unauthorized material, which was not.
Causing a loss of 16 lakhs. So in effect, it is that. Now, what do they rely on for that? The only thing they rely on are 2 things. Lordship, I will take you through the inquiry report, exactly how the inquiry report for Digonta Hollow it has been. The finding is there is no evidence from record that there is a designated scrap area. Okay. So that is out of the way. So from different areas, the allegation that I have allowed or I have not effectively supervised take loading from different areas does not stand, because there is no evidence from their own witnesses that there is a particular designated area, whether it's SS3, whether it's OY1, or whether it's that area, it's all together. And there is no evidence that there was a mandate to take out only from one. That is their evidence established in the inquiry report, exactly the same as it. So that is out. Now the question is, what is it that went missing? The first report only found 2 coils. That's the first report ever. 15th of March was the seizure. The first report is of 20th of March, 5 days after. The day when the verification happened on 20th, I was not called. So I was not part of it. Only thing that was found was 2 coils. So what do? They say, and what is the nature of the coil? They say 2 coil of cables of quite large dimension. That is the only thing till date is established. That is the only thing till date is established, nothing else. The only other thing that is established other than that is APDCL saying this is not usable. So evidence, so to speak, is there are quite large dimension cables, 2 coils, and APDCL saying this is unserviceable cables and scrap only. Now, what do they come and say that no, there is something missing? Something missing is of a report of 9th of April, 2014.
Then physical verification.
And that is after 1 month. And Lordship, what is important is one document which tells you what happened in that month. And that, Lordship, I will, page 221, I will request your Lordship to see it. Because a lot says about the appellants on this. Page 221.
Wait.
221.
Yes.
Lordship, there were complaints made. This is all arising from journalists complaining. And there were complaints made in the criminal court as well. And this is one such order.
What it says?
Yes, Your Lordship. I will read it, Your Lordship, because this is an important order. Why is it important, Lordship? Because what is integrity of what is seized? What is the integrity of what is in Numaligarh warehouse, whatever name you call it, is in question mark. We do not know. And the Honorable Chief Justice.
Ultimately, what happened in this complaint?
Lordship, may I read it? Because what happens is important. May I just quickly read it? Page 221. This is dated 20.
We'll read it. You just show us.
Yes, Lordship. If I read it, it'll become clear. If I read it, it'll become very clear. This is to show that materials were allowed to be taken by Numaligarh after being seized to Stelex.
That the seized material.
Yes, was allowed. They took it. Then it was brought back. So what was the integrity of what was seized is we don't know. In that
There is no
circumstance,
possibility that
there could be somebody who took
may be
it.
changed
Yes, Your
or
Lordship.
everything.
Absolutely.
Yeah, we understand. Yes.
May I read this then, Your Lordship?
Ma'am, we'll go through it. Then take this paper.
Lordship, and there is a thing on conduct of Lordship. May I read this? I have 15 more minutes and I'll quickly read it, Lordship, quickly.
Relevant para.
Okay, Your Lordship.
21.
Lordship, I will read it fast. Lordship, it's on 21st of March 2014. 21st of March 2014.
July.
21st of, no, this is, order is date of 21st of July.
Okay.
1, 2, 3, 4, 5, 6, 7th line.
Yeah.
On 21st of March
One
2014.
Sanjeev
Yes,
Hazarika.
one Sandeep Hazarika on behalf of Stelex. And Stelex is the person who was auctioned to, the L1, who was supposed to take all the stuff. Stelex filed a petition under so-and-so seeking custody of materials that police seized. This court called a report from police. Then only police admitted about seizure of 3 loaded trucks with some scrap material. The petitioner claimed that those materials were purchased from NRL as per e-auction so-and-so. Again, the police was directed to make an inquiry and submit report in this regard. From the report of the police and materials collected from NRL, it could be learned that NRL had sold some materials to Stelex with the auction notice so-and-so. According to the petitioner, police seized those materials while were being carried. Considering all the materials on record and having heard both parties thereafter, the court directed to deliver the e-auction material to Stelex on execution of a bond. This is happening on 21st of March 2000, 6 days after the seizure. This court further directed the investigating officer to confirm from NRL prior to handing over the material whether the materials seized were e-auctioned or not. After some days, a petition is filed from the NRL stating the NRL could know that those articles were not e-auctioned materials. So what was seized was not e-auction. The e-auction materials are still lying with them. NRL authority admitted that those e-auction materials were sold to Stelex. So what is seized, what is lying with them. Thereafter, this court heard the NRL authority in presence of the investigating officer and having heard both sides directed the investigating officer to return the articles that were in custody of Stelex. So they gave to Stelex and then it was directed to give back to NRL. Receiving the said order, after about 1 week, the investigating officer appeared in court and let the court know that he had given the seized materials to a Sanjeev Hazarika representative of Stelex. So that seized material was given away. Therefore, not to speak of about the seized materials unloaded from the trucks, even in case of trucks also. The IO has flouted the court's directions as the court had directed the IO to deliver the trucks to register's owner only and the material to the owners after consultation with NRL. Thus, this court opined that IO has violated the order so-and-so. After some days, now even more curious, Your Lordship, after some days, NRL authority has appeared in the court with a petition with an amazing prayer, restraining IO from seizing the auction articles. I found surprise in the attitude of NRL authority. On one hand, it is said the e-auction lying, I'll go a little slow on this. On one hand, it has said the e-auction articles are lying with them. On the other hand, when the IO wanted to seize those, if they were lying with the authority, they wanted to restrain the IO from doing so. So this attitude portrays dubious scene in the background. So is the attitude of the local police. And then, Your Lordship, because I have no time, Your Lordship, it then says, Lordship, page 244. Page 244. Second line. Therefore, in this, Lordship has page 244. First point is তারপর ঘি দিতে তারপর আর কি হয়েছে আমি না জানো
What happened then?
Lordship,
No, what happened to this order then? The investigation was carried out by.
yes, now I think charges are being filed and it's going on.
Against whom?
No, this is a Jimna order, sorry, this is the case is going on. I'm an accused there.
You're an accused.
Yes, I'm an accused there, but I believe the complainants have gone missing. So nothing really much is happening. The same journalist, I think,
Both are complainant. No, both are accused there.
both are accused there. Lordship, the reason I brought this is on 21st of
You mean to say that first it was seized, then it was released, and then
it was brought back. And NRL did not know whether what was seized was part of auction or it was not part of auction. In such a situation, how do you rely on an inspection report done much after all of this? The material is gone, the material has come back to say something is missing. And that something is missing is innocuous. It could be by anybody else. It becomes relevant.
By these persons or that.
Yes, and it becomes relevant. Why? It becomes relevant when you compare it with what they're saying is a video. Then you decide the video.
No pointed.
Yes. Lordship, there is one no, High Court media got it. Lordship, because it's important, it's absolutely correct. Roop Singh Negi is what's relied on. Lordship knows, I will not impress upon it, that while strict rules of evidence is not applicable, principle of natural justice is.
That is there.
Yes, and that relying on that, there's a Delhi High Court judgment which brings in 65B to disciplinary inquiry on the ground. Why? Because how else do you prove electronic material? There has to be a way of proving electronic material. Both cases cited by the learned senior for the for the appellant is 1977, before 2000, and electronic media was admissible. Here is a situation where how do you prove electronic? Anybody can come up with anything and say anything. And if there is if this particular electronic video is discarded, then all you have is a belated inspection.
You point out the
Yes, yes,
para
yes.
in this case.
I go to go to 51 into detail. Lordship, para 51. In fact, Lordship, para 48. Lordship, I'm hurrying, so para 48, which basically says the Supreme Court and so held department inquiry is quasi-judicial, and although the provisions of Evidence Acts are not applicable, principles of natural justice are required to be complied with. The court exercising power of judicial review are entitled to consider whether the relevant piece of evidence has been taken into consideration and irrelevant facts thereof excluded therefrom. And Lordship, it goes on, and then 50 is what it discusses Anwar PV, which also the single judge relies on, which is the case of 65B, that if you want an electronic document, then it has to be as per Evidence Act. That is AP Anwar PV, and applying Anwar PV, then it goes on to 51. And it says, this court is conscious of the observations of the Supreme Court that strict rules of evidence will not apply to departmental proceedings. However, as noted above, where the evidence sought to be pitched against the charged officer is electronic evidence and is alleged to be doctored, tampered, or unauthenticated, principles of natural justice requires that the same must be supported by a certificate tendered in accordance with principles of Section 65B.
Alleged to be doctored, tempered, and unauthorized.
Unauthorized, which is what we will say, that it is not.
You're simply saying that.
Lordship, we've said, that is why it went for further inquiry. Lordship, the first inquiry report held partially, and said there are photographs.
No,
we then came to the appeal.
Inquiry report, even those photographs were not presented.
No, they were presented, and we said no. Lordship, may kindly take a look.
Those were not produced.
The inquiry officer rejected it. He did not take it. Then he was directed by the disciplinary authority to take it. They did not take that objection. No, what the objection in terms of this?
Lordship, page 165. Yes.
At the last moment, the shop to be introduced.
Has refused, but you have not said that this is doctored or something, you said.
Yes, your lordship.
It is not visible.
This is.
We couldn't open them.
Page one.
Lordship may see page 169, what we've said. We have said we can't even open it. Lordship, the first inquiry report happened.
That here, we'll go through this judgment, but what you have read now, it says if it is contested or say that it's a doctor, then 65.
Lordship, we have definite, both of us, we have contested.
When they gave us a notice, we immediately responded by saying that how can you?
That is altogether different. How can you produce the person who has recorded this? Where is that? You have not.
All those objections are there.
Lordship, a fair hearing and a fair decision will involve that what you've tendered as evidence is authentic, whether I make a submission in that regard or not. At the end of it, to constitute legally evidence, it has to be an authentic form of evidence, even if I have not said it. Lordship, but we've taken that ground. In fact, it went back and came back, and when we came back, additional inquiry or report, we said that we can't even open. So as of date, we can't even open. We don't even know what those photographs says. So that is a clear breach of principle of natural justice. And in any case, Lordship, now almost it's standard. Tomorrow, if I want to tender a video, your Lordship will not take it unless I give a 65 AB. That is the procedure now, whether it's criminal or quasi-criminal. Lordship, now, page 162 as to how did the inquiry report proceed. Lordship, I've given you my submissions. I'm not repeating the same.
We'll consider. We'll consider.
Page 170.
But then we will go through all the record and then only we'll.
May I just take you through what the inquiry report has done? Page 162.
We'll go through it, ma'am. We'll go through it. Don't you worry.
Page 162.
Yes. Order is up.
There's no finding that
Yes, that is.
Again, still it is long and short. We will, yeah. Then why you argued for?
No, long
so
and
much
short,
time?
your Lordship is.
If it's so short.
No, Lordship, long and short is nobody knows what was seized, what is stolen, and if at all there is anything stolen. That's the bottom line.
Order is up.
Yes, your Lordship, that is the only thing.
See to it.
Very good.
My lord, item number 25, the very next item, my lord, there is some urgency on our part where the appellant, can it be on 22nd, my lord?
We'll go in the next month, June.
My lord, because the settlement was in our favor, however, that has been there.
We'll hear it in June. June.